That's funny, the guy at the end keeps telling me don't speak.
Good morning. I'd like to welcome everybody to the regularly scheduled Planning Commission for May 12th, 2022. If you would, please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. All right. Good morning, Ms. Light. Are there any changes to the agenda?
Yes. Good morning. Item number 1, LDCT 2202, Ordinance 2226, Land Development Code Text Amendment, County-initiated agritourism. We have a public comment letter. Item number 2, PDPM 2110 CG, Port Authority, Manatee County, Port Manatee Master Development Plan, Certificate of Eligibility, uses by the state agency, new traffic statement, acceptance letters, and changes to the transportation table in the staff report. Item number 3, PDMU 2115 CG, Circa Italia, 33rd Avenue is rezoned, and is additional public comments, revised specific approval request, and revised staff report attached. And item number 5, PDMU 1806GR, Village of Amazon South, and is revised motion to remove the action of the Planning Commission language from both alternative motion attached, and also there is going to be additional changes to the staff report that are going to be entered into the records during the morning.
Very good.
Thank you.
Very good. Thank you. All right. Anything from the County Attorney's Office?
No, Chairman, not at this time.
Very good. All right. We have an item scheduled time certain, so we're going to go into that application immediately, and then we'll go back to public comment for anything that's not on the agenda. So if we could, let's go ahead and get item number 1 read into the record.
Item number 1, LDCT 2202, Ordinance 2226, Land Development Code Text Amendment, County-initiated agritourism, is a legislative case amending the Land Development Code by adding agritourism to Chapter 2, Section 200, definitions, Chapter 4, zonings, Section 401.2, Schedule of Uses, and Chapter 5, a standard for accessory and specific use and structures, Section 531.1, Agriculture Uses. The case manager is Bill O'Shea, and here is Ms. Nicole Knapp to introduce the item.
Good morning. Is this a
Legislative.
legislative?
Legislative,
Okay, thank you.
yes.
Thank you.
Good morning, Commissioners. For the record, Nicole Knapp, Comprehensive Planning Manager. And as Rosina explained to you today, we are here for a Land Development Code text amendment regarding the topic of agritourism. So since approximately October, the staff has been working with a consultant, SNME, sorry, I always get tongue-tied when I say that, through varying stages of the project, and they're here today to make a full presentation for you. So with that, I'm going to introduce Pat Tayaski, and she'll take over the presentation from here.
Thank you.
Right here. This one. Yeah, thank you.
Good morning. My name is Pat Tayeski. I'm with SNME. I'm a planner. I have a short presentation that I'm going to take you through. We're going to talk about the project scope, what we were tasked to do. We're going to talk about the schedule. We're going to talk a little bit about the background of agritourism, then some research that we did on peer review, then the actual proposed amendments, and then we'll have some discussion, question, and answers. In terms of the scope, so the county staff came to us and said, we need to do something about agritourism, and the first thing that we want you to do is just go out other places in Florida and see what everybody else is doing. Then we're going to consider some amendments. And tentatively, we said, okay, it's probably going to be definitions, something related to location, where these activities could locate. Maybe some standards, see if that's something that we can or should do. And then, of course, the approval process. Then the idea was to have a workshop so we could get some public input and then go through commissioner briefings and adoption. In terms of the schedule, like Nicole mentioned, we started back in October. And right now, we are in May. We had the planning task force workshop last week, I believe. And then we have this hearing today. In about 2 weeks, we're going to have briefings with the commissioners, and the plan is to have hearings in June. And just as an FYI, when we had the planning task force workshop, it was a virtual meeting, and we had about 15 people show up. And based on what staff told us, typically we get about 7 people attending those meetings. So they felt that we had a little bit more than normal. So background. So the agritourism word first appeared in the statutes back in 2007. And the idea was to allow farmers to open up their farms to visitors. The statutes have been amended over and over again to address different issues. One of the amendments was to address liability. When you have an agritourism activity, you're supposed to post a sign saying pretty much that they're not liable for whatever happens on the site. So you're on your own. You assume your own risk. Later, they were amended to prohibit local governments from enacting or enforcing regulations that would prevent agritourism. Now, that caused some backlash, and they had to go back and amend the statutes again to say that, well, no, the local jurisdictions do have to look at, they don't have to, but they can look at substantial off-site impacts. So they all agree that whatever happens on the site, we're not going to regulate, but it is the county's responsibility to make sure that they're not going to impact, the rest of the county in a substantial manner. Then later, they were amended again, and this time it was to include civic and ceremonial activities, such as weddings. And the last amendment that we heard of, it was this year, and it was to address an issue with buildings. And we're going to go through some of these in detail in the next few slides. So let's start. These are some excerpts from the state statute. So this one is the Florida Right to Farm Act. If you look at the last sentence here, it says that it is the purpose of this act to protect reasonable agricultural and complementary agritourism activities conducted on farmland from nuisance lawsuits, basically. So that's something to keep in mind, that's the purpose of it. Then we go into the definition section. So it's like, what is agritourism? So the statutes define that as any agricultural-related activity consistent with a bona fide farm. So you can't just plant 3 trees and say you're agriculture. You have to be classified as agriculture. So it's either a farm, livestock operation, a ranch, or in a working forest that allows members of the general public for recreational, entertainment, or educational purposes to view or enjoy activities including farming, ranching, historical, cultural, civic, ceremonial, training and exhibition, or harvest your own activities and attractions. So as you can see from that sentence, it includes a lot of activities. And then it says, however, you're not an agritourism activity if you're going to construct a new or additional structures or facilities intended primarily to house, shelter, transport, or otherwise accommodate members of the general public. So if you have your farm and you have a barn and you're going to use it for weddings, you're fine. But you cannot just go and build a chapel and say, I'm a farm. So, that's a key portion of this section. And, whether they do it for free or charging a fee, that doesn't matter. It's still, an agritourism operation. Here's one of the latest amendments. It says a local government may not adopt or enforce a local ordinance, regulation, rule, or policy that prohibits, restricts, regulates, or otherwise limits an agritourism activity on land classified as agriculture. So again, we cannot say, oh, if you're going to have agritourism, these are your setbacks and your buffers and, so many spaces per 1,000, whatever. We can't do that. However, the next sentence says, This subsection does not limit the powers and duties of a local government to address substantial off-site impacts of agritourism activities. What is substantial? They didn't define it. What is off-site? They didn't define it. So those are some of the issues that we have to deal with. But the bottom line of this is that we cannot adopt standards for whatever happens within the site, but we have the authority, or the county has the authority to look at substantial off-site impacts. Okay, this was the last amendment that we know of. So basically it says that if you have an agricultural operation and you're running your agritourism activity, that the county does not have the power to go and close them down just because they have, or because they're constructing or altering or maintaining a non-residential farm building, structure or facility on a bona fide farm which is used to conduct agricultural activities. So basically if somebody comes in and says, I have this building, it's part of my farm, and the county says, no, that's not part of a farm, that's something else, as long as it is a non-farm building, they can do it. And they even give examples here. At the very bottom in red line, it says, what is a non-residential farm building? And they give examples. It may include, but not limited to, a barn, greenhouse, shade house, farm office, storage building, poultry house. So, there are some areas that are not specifically defined, but there are others that they do include definitions. So the peer review, that part was not very successful because we checked with a bunch of counties around the state and couldn't find a lot of them having any provisions in their land development code related to agritourism. So this is the list of all the counties that we looked at. And we only found references to agritourism in Collier County, Osceola County, and Lee County. So we looked at those three to say, okay, what are they addressing? How are they addressing it? So Lee County, they align their definition with the Florida statutes, and basically they require a special events permit if somebody's going to have an attendance of 1,000 people or more. Collier County, they require a conditional use permit, which is the equivalent to special use permit here, for some cultural, ecological, or recreational activities. Now, when you read through the standards, it's pretty clear that they're talking about off-road driving activities. In Osceola County, it was something similar. They have some standards, but when you read through them, you realize that it's trying to address upscale camping or glamping operations. So those were the only three examples that we found out there that had any record of agritourism provisions. So in terms of recommendations, so we are focusing solely on substantial off-site impacts. I mentioned that substantial is not defined in the statute. So it's very obvious when you think of a farm that maybe they grow strawberries. You pick your own. We've all done it. We've all seen it. We know it doesn't create a substantial off-site impact. There are no lines of cars waiting outside to go in. Let's look at the other extreme. An agritourism activity that attracts thousands of people, and there is music, and there is traffic. When you look at it from the inside, we can't do anything about it, but let's look at it from the outside. So these pictures here, you pick your own, you drive by and barely notice it's there. The other one could cause long lines of traffic, safety issues, and safety is one of those items that keeps coming back to our minds when we talk about substantial off-site impact. So it's basically the public health, safety, and welfare. We'll always go back to those three. And when we think about off-site impacts, this list is the typical that comes to mind. Are you going to have a lot of people? What is that going to do to traffic? What is that going to do to the environment? What about the health of people surrounding that area? What about the noise? What about the odors? Well, noise and odors are things that we cannot look at because when we talk about agriculture, they're always exempt from those two. So those are two items that just go out the window, can't really look at them. So we're left with, how many people they're going to accommodate, what is the traffic going to be like, are there any impacts to the environment, and are there any impacts to the health of the people in the county? So when we were going through this, we were trying to say, okay, so how do we determine what is substantial? When do we start looking at them? We don't want every mom and pop operation of you pick your own fruit or vegetable to have to come through a process. That's not the idea. The idea is to set up a triggering mechanism that would make those that are potentially substantial offsite impact creating activities to come to the county and be reviewed for that purpose. So we, after looking at maybe do it based on traffic, maybe do it based on one thing or the other, we came up with just attendance. It's something that they have, and readily available. We don't want them to have to do a traffic study just to apply, so just base it on attendance. So we're using the same number that Collier County is using, just 1,000 people. If you have 1,000 people or more, then you're going to have to come to the county and show that you're not going to create substantial offsite impacts. Now, what process do we use? So there are many different processes that you see coming through, either through this commission or through the board or through the hearing officer. But we found out that the special permit is the most appropriate process for them to be reviewed under. When we look at the definition of what a special permit use is, it says that those uses are deemed to be generally compatible with other land uses permitted in a zoning district. However, because of their unique characteristics or the potential impacts on the surrounding neighborhood and the county as a whole, such uses are subject to individual review of its location, design, configuration, operation, and the public need for that particular use. So it makes sense that if anybody's going to review an application for potential impacts, this would be the way to do it. When the hearing officer is the authority that approves, that reviews special use permits, when that person reviews one application, they go to Chapter 3, and they have the criteria that they have to make sure the application meets before they approve the special permit. A through H, I'm not going to go through all the details, but basically it's consistency with the comprehensive plan, the land development regulations, the public safety and welfare of the public, adequate means of access, egress. Some of these criteria may not be applicable. If the criteria is talking about how the transportation works on the site, well, we know that we're not going to regulate that. But how the transportation is going to affect the surrounding areas, that is something that the hearing officer would be looking at. And then, so, how are we doing this? So, number one, we would need to add a definition to Chapter 2, and we're going to copy-paste the same definition that the statutes have so that we're consistent with the statutes. Then we have a table of uses in the Land Development Code. It's Chapter 4. Basically, if you're going to have, let's say, a daycare, you go down the list, look at the districts, and you determine, okay, it's a permitted use, or it requires a special permit, or it's a prohibited use. So we're going to be adding a P for permitted for agritourism in agricultural districts if they're hosting less than 1,000 people per day. If they're hosting more than 1,000 people, then they're going to be required to get a special permit. Then we're going to go, we have a chapter in the Land Development Code that has specific regulations for certain uses. It's Chapter 5. And there is a section already in place that talks about uses in agriculture districts. So we're proposing to include a subsection there that will explain how that special permit is going to be reviewed and what the applicant would have to submit in order to allow the county to review that special permit. And then there is a provision in the code that says that whenever you get a special permit, you have to get your site plan approval within a year, or that special permit expires. We are not asking to take the agritourism activities through an engineering type site plan review process. We're saying once they submit a conceptual site plan for the special permit application, that should be enough. Once they get that special permit approved, they are approved. A question came up at the planning task force regarding the cost of a special permit. So right now, a cost for a special permit is a certain amount. County staff is looking at reducing that fee because in this case, they're not going to be looking at the site, on the inside of the site, they're just looking at the outside impact. So that fee will be reduced. And with that, I'll just take any questions that you may have or comments, suggestions.
Thank you. Any questions regarding the presentation?
I have a question, and that's, first of all, very interesting. Great place for this, I'm sure. My question is a little bit about facilities. So, you go to U-Pick and whatever, you're kind of out in the farm, that's kind of expected. If you have, I saw a thing in Polk County where they had an archery program, and they were out shooting styrofoam animals and so forth, and they were out in the woods. And so there was, anyway, my question is, what kind of facilities are you going to be obligated to have if there is no external impact by the number of people? I mean, you're going to have water, bathrooms, any other kind of obligations, water facilities for hydration or anything like that?
Yeah, we go back to this part here that talks about facilities. Let me go back to here. Let's see, it's the previous one. Okay, so additional structure. So if you're going to build permanent public restrooms, you're not agritourism anymore. If you're going to bring porta potties, it's fine. It's not a structure. It's not permanent. It's fine. If you're going to build a restaurant, you're outside of the definition. It's not related to However, if they have a barn and they're going to set up tables and they're going to sell hot dogs from those tables, that's fine.
Food trucks are okay,
Yeah. Yeah, as long as you're not building something to,
permanent.
yeah, yes.
And that would include something that is ancillary to the primary use, the agricultural use, like, it's not uncommon to see like a stand or something like that where they sell produce. So,
And I think the code addresses those stands anyway, that they're related to agriculture, yeah.
okay,
So.
all right,
And what about sorry,
go ahead.
no,
Mr.
Mr. Delasla.
All right, Mr. DeLeslie.
On the special use permit, would you get one per event, or would you get it for the whole year?
So that's something that we're leaving it up to the hearing officer. If they feel that it is an activity that should be reviewed in a year, they could say, come back in a year. If it is something that they're feeling like, oh, this is not going to create any issues, it just barely missed the trigger line, they could say it's a permanent special permit.
I meant like if you're going to have a concert on 4th of July. But could that special use permit be used for Thanksgiving weekend too, or?
No, I mean, when you approve a special permit, it's specific to an activity. Like the question came up in the planning task force. What if you get a special permit for 1,500 people? It gets approved. You open and you have 2,000 people. They run the risk of being shut down. They have to meet that special permit. Could they come and apply for 2,500 next time? They could. They could. If they can prove that those 2,500 are still not going to create substantial offsite impacts. But it's just like whenever you do a special permit for any other use, it is expected that it's specific to that use, that if you deviate from that, then you're not within the approval.
But date doesn't matter then.
Yeah, that's what I'm saying. Like, it would be up to the hearing officer to say, we'll give you a special permit, but this will expire in 6 months, or it will expire in a year, or no expiration date.
Okay, but what I'm saying is, if you want a 4th of July concert, would that be specific for 4th of July, or would you be able to?
If you want to have it flexible, you could come and tell the hearing officer, I want to have a concert permit, and it could be for any holiday in the year.
Okay. Thank you.
And for safety, I mean, obviously, that's one of the big things. You talk health and safety, so facilities. Security is always kind of a discussion. So if you only have 500 people and they're rowdy, they're under the limit of being reviewed?
Yeah, well,
I'm thinking of the coleslaw wrestling thing they have. You may not be familiar with it. So, but there's a whole bunch of people that go to Central Florida and they show up and you don't know, have any idea. Anyway.
yeah, and that was
A
the,
group that might be considered raucous, not my
Yeah.
revealing
something about himself.
that was the challenge with the 1,000. It's not a magic number. I can't say that we have done study after study after study to come up with that 1,000. And, if you, like with any code regulation, if you start enforcing it and a year later you go, the 1,000 is not working, we're going to have to revisit this. Let's change it. Or maybe it's the other way around. The 1,000 is too restrictive. Let's, look at increasing that.
So one of the things we found when doing events is that there are some municipalities that require that you have police officers or duly deputized county authority, which would be sheriff, police, et cetera, whereas a lot of people use private security or security teams or whatever. What's the analysis of that?
We didn't go into that specific requirement, but we are talking about emergency services, police services, traffic, so the applicant would come up with a plan. So if they come in and they say, we expect everybody to take a bus and come in a bus. Oh, you're going to have 1,500 people, but everybody's coming in a bus, so there are no substantial traffic impacts off-site. So, if they come in and say, everybody's going to come in their own cars, but we're going to hire traffic people, and they're going to be standing at this intersection and that intersection and that intersection, the county looks at it and it's like, that's good, because that way they're not going to block these intersections. People are going to be able to get home. The ambulance is going to be able to get here to this place in case something happens. So it's all site-specific, and that's why the special permit seems to be the right way to go.
Because
Then you
in
can-
Smith Stadium, when they have a lot of cars, they have people standing around, they're not deputized, but they're,
They can be a private security, yeah.
okay.
As long as they have adequate access for county services, emergency services, then that should be fine. And that's something that they look into, they want to make sure that they can get there.
Sure. Thank you.
If there is an existing operation, agritourism operation, let's say maybe it is something like the strawberry U-Pick, but whoever's operating it deems that it's necessary to do an improvement like a parking lot, a shell road, something like that, that facilitates actually bringing people in and getting them back out, is that a violation of the designation of agritourism if they're having to do improvements to facilitate?
No, that's what we're talking about, that whatever happens on the site, the county doesn't really have a say. If they have less than 1,000 people,
Yeah.
the county can't really go and say, oh, you need to mark the spaces, or you have to add handicap spaces.
Okay, so the handicap accessibility is not a
It's not anything
consideration?
that the county can do. no.
Okay. And a couple times we've mentioned the special permit and the hearing officer. What department is the application made to for something like that?
Development services,
Okay,
yeah.
okay,
Yeah, and typically the staff will prepare a staff report
okay,
bring it before the hearing officer.
all right. Any other questions? Okay, thank you.
Thank you.
All right, we have one speaker card. We'll go ahead and call up folks for public comment after this. If anybody else wishes to come forward, please do. But the speaker card I have is Nicole Pote. Good morning.
Good morning. So in addition to my public comment, spoken public comment, I also prepared a written public comment that'll go through in more detail some of the concerns that we have with the actual language of
Okay.
the land
All right,
development regulation.
and if you could, just please state your name.
Oh, yes. So my name is Nicole Pote, and I'm an attorney with Lewis, Longman, and Walker.
Thank
And
you.
Lewis, Longman, and Walker represents two clients that own agricultural land in Manatee County that will be impacted by the proposed land development regulation pertaining to agritourism. Therefore, we wanted to take this opportunity to offer comments on the proposed land development regulation. So as Pat mentioned, Section 570.85 of the Florida statutes prevents the county from adopting or enforcing a local ordinance, regulation, rule, or policy that prohibits, restricts, regulates, or otherwise limits an agritourism activity on land classified as agricultural land. The county's ability to prohibit, regulate, or otherwise restrict agritourism is further restricted by the limitation of duplication of government regulation set forth in Section 823.41, subsection 6, Florida statutes, Florida's Right to Farm Act. The purpose of the Right to Farm Act is to protect agricultural and agritourism activities conducted on farmland from nuisance suits, other similar lawsuits, and undue government regulation. So Section 570.85 only allows a local government like the county to address substantial off-site impacts of agritourism activities. This law does not allow a blanket prohibition of agritourism activities or regulation of on-site activities. It is clear that the proposed land development regulation goes beyond what is permissible by Section 570.85. The proposed land development regulation attempts to regulate significantly more than substantial off-site impacts Additionally, the nature of the proposed LDR fails to discern between general potential offsite impacts that are a result of agritourism activities and those offsite impacts that are a result of routine agricultural operations. This is contrary to the purpose and scope of the Florida Legislature's agritourism protections. Moreover, we believe that the proposed land development regulation is inconsistent with the county's comprehensive plan. Specifically, the proposed LDR directly interferes with the private property rights of agricultural landowners and therefore is inconsistent with the comprehensive plan's property rights element. Additionally, the proposed LDR, in that it regulates on-site impacts, runs afoul of relevant Florida statutes. There are a number of issues with the proposed LDR that should be addressed before the Planning Commission makes a determination regarding consistency with the comprehensive plan. Really quickly, one of those is that there is no indication in the land development regulation why the 1,000 attendee number was selected or why this number of attendees automatically requires an extensive permitting process. And with that, it is our opinion that the proposed land development regulation should be abandoned or revised and revisited by the Planning Commission prior to its submission to the Board of County Commissioners. The regulation as presented today leaves the county and its citizens open to costly lawsuits and fails to comport with Florida law.
Very good. And you said you have a written summary also that you can provide to
Yes,
staff?
I
Okay.
gave it to the clerk and
Okay,
Mr. Soto.
thank you. Could you please give an example how you feel it violates? I understand the rules and the way it's presented, but I'm having a difficult time understanding how it might be, in application, how it might violate it.
How it might violate the statutes.
Yes, ma'am.
One of the issues is that, for example, there isn't a definition in the Florida statutes as to what constitutes a substantial offsite impact. Similarly, the Land Development Code doesn't enunciate or state what a substantial offsite impact is. I understand traffic slowdowns might be inconvenient, but at what point is that an actual substantial offsite impact? In addition, the LDR purports to regulate potential impacts instead of looking at agritourism events that have occurred for decades in the county and what substantially affects the community at large.
Okay, all right, thank you.
Can I ask one question?
Sure, if it's
So,
helpful.
very interesting. So it kind of goes to my point of what, is it 500, is it 1,000? And so my question kind of goes back to, it says, again, who is the arbitrator of substantial impact? And is it traffic? Is it buses? I mean, there's all kinds of things say substantial and what's an impact, and you're not allowed to impact it by state law. How does the 1,000 arbitrarily set that thing? And do you represent groups who can say that they've had experience with events with large number of peoples over longer periods of times versus music, which is more concise, and they've had experiences successfully operating this?
Yes, absolutely. We represent Hunsayer Farms and also.
I was thinking of them. Anyway, I
Yes.
guess my question is, have you been approached to get your insight on this for this submission?
To the extent, our input has been limited. We are in the process of going through a special permit for our other client, Malloraney LLC, who runs the Medieval Festival. And with respect to that,
Them too.
and with respect to that, one of the big concerns with this is in that there isn't designated timeframes in the proposed LDR. There's a major cost associated with it. To the extent you have an event that is, let's say your event is in October, well, we're still going through the process, so there's no timeframes on that. And to us, it's arbitrary in that we're not clear on what constitutes a substantial offsite impact. Is a 15-minute traffic slowdown an offsite impact? Is a 30-minute, at what point does it become a health, safety, welfare concern with respect to traffic? And also, in our written materials, we talk about some of the on-site impacts, to the extent a site plan is required. Well, how is that affecting public health, safety, and welfare off the site? And so that's some of the things we've talked about.
I think that's the thing that kind of comes to my mind. And and I know Mr. Delesline has done events and so forth, is involved in stuff where we have to go get permits and how hard it is, and you could argue the valuation of that. I do think the protection is a critical part of that, and I would argue that everybody would want that. But then the decision maker, who that is, like you said, who does it? Are they experts in event programming? Do they have knowledge of security issues? Like, I can tell you, doing mall programming, night issues are much different than daytimes. I did a circus on the mall one time. I don't recommend it, but it wasn't, the lions at night roaring were not a planned event. So I just think this is very interesting. I like it. I think we're a great spot for it. I do think you have a lot of good points, so thanks for coming in.
Thank you. With that, we'll open it up to anybody else in the audience who wishes to come forward and make a comment or statement regarding this application. Anyone at all? Okay, seeing no one else come forward, I do have a follow-up question for staff. Our
Ms. Chayefsky?
consultant. Yes. I want to use the proper terminology. Were there discussions with like user groups, people who currently are operating events that maybe would be affected by
The
this?
planning task force workshop was the only time when we had that, and we had a person who was vocal about that during the meeting. But it was not a targeted effort to invite those people to come in.
Was there anybody in attendance who was associated with events? Ms. Knapp is shaking her head yes. So.
Yeah, like, the person was saying, I know people who are doing this, what's going to happen to their operations?
Right.
That
Okay.
was a common question, like, is the county going to come and get everybody and get them, to shut down? So it was like, just like with any other regulation that you have in the code, if you have, a setback regulation and you know that there are some homes that exceed that setback
Right.
already, it's not like you're going to go and shut them down.
Right.
So typically what happens in those instances is that when it becomes a problem, then you can address it.
Yeah, I can imagine just if you're not actively involved in it, you can guess what might be problematic, but it's unlikely you're going to be able to guess everything, all the scenarios, so. I think
And
it would be
the question
important.
about the site plan, we're not looking at the site plan to see how the operation works on the inside. If we look at the site plan and see that they don't have any parking accommodations, we go, oh, where is everybody going to park? Are they going to block all the entrances to the properties next door? That's why we want to see the site plan. Where is the ambulance going to come from? There is only one way of access, and everybody's going to be lining up to come in. How is that ambulance going to get there? So,
Ms. Chayefsky,
Camilo
could
has-
you maybe, I don't know if this is possible, but could you pull up, we're having kind of technical issues, but Part 5 standards for specific uses, and that kind of lays out the various kind of off-site analyses that I think go into this, and that might be helpful maybe to
Was it part of the presentation or part of the proposed?
It's part of the proposed ordinance.
Okay, I can use this machine here.
And it's page 6 of 7 of the ordinance that's been uploaded into the agenda system, if that helps commissioners get there.
Is this what you're talking about?
Having trouble seeing it? This is exactly, yeah, that looks like it, yes.
And then there is, let me just 1 second. Or this part.
And just a discussion of the different points that are there as far as how that relates to off-site impacts. I think that might kind of help bring everything together. Because we've been talking about the site plan and how that works, but I don't think it's.
Oh, the one that said crowds, traffic?
Correct.
Okay, so that's the PowerPoint.
And so, well, no, I mean, but as far as how it's detailed here in the ordinance, so if we could kind of tie that into what's in the ordinance itself, so that way it kind of brings some meat to the bones.
Okay, so this is the actual amendments to the Land Development Code. So that's the Chapter 5 where we have specific standards for different types of uses. So basically, it says, if you have less than 1,000, you're permitted. If you have more than 1,000, then you require a special permit. And then here we talk about, they need to have access from a paved road with adequate capacity to address the traffic. So if you have a 2-lane road, no shoulder, ditches on both sides, and you expect a long line of cars, what is that going to do to the public safety and welfare? You know, the ambulance has to get there. How's the ambulance going to get there? Now, in terms of demonstrating that, the county has a 2-level process to review traffic. So one is the traffic impact statement, and the other one is the traffic impact analysis. One is shorter, cheaper than the other one. We're saying you need to show us, you know, with numbers, how that traffic is going to get to your site. Are they going to block an intersection? Are they going to go in front of a fire station? You know, we want to see those situations. And then when they submit that traffic impact statement, if it's raising flags, the staff would have the ability to request the next step to demonstrate that, okay, we've looked at it in more detail, and this is how we plan to solve it. And all these issues is, anytime that there is an issue raised, it's not like it gets automatically denied. The applicant can come up with solutions to that issue, mitigation strategies. So the number 2 has to do with the site plan. And again, it doesn't say that it's going to be a fully engineered site plan. It says a site plan must be submitted to the county depicting the location of the proposed activities, vehicular circulation, and parking to demonstrate that large crowds and vehicular activity not commonly associated with an agricultural operation will not have a substantial impact on the surrounding properties. The next one talks about site plan shall show adequate access for fire, law enforcement, and EMS vehicles to enter the site. All parking must be provided on site. How do we know that unless we see a site plan? Permits or letters of exemption from all other agencies would need to be submitted. They need to post the property consistent with the statutes in terms of liability. The next one, it says that they have to comply with the noise ordinance, but it's, you know, when you go to the noise ordinance, they have a lot of exemptions anyway. So it's not like, they would not be treated just like any other, you know, commercial business or residential activity in the county. Molestation of wildlife, including feeding, shall be prohibited, and that's something that is, you know, everybody. Again, we state that they cannot build new buildings or modify buildings, and it repeats what the statutes say. And the next page, it talks about, for the hearing officer, okay, so that person is reviewing the special permit, what are they going to be looking at? Because some of those criteria really refer to site-specific items. So we're saying for criterion C, because that one says the establishment of the use shall not impede the normal and orderly development and improvement of surrounding properties. So we're saying that they just have to demonstrate that their agritourism activity is not going to interfere with the operation of agricultural or residential activities on the surrounding sites. No, we're not going to, you know, talk about noise that it's, you know, when you have a farm, there is noise. There are tractors and machines, so it's expected. So it's not like we're going to go into that detail. Criterion D, it talks about ingress and egress. So what we're looking here is demonstrating that the activity will not cause traffic, safety, or access impacts on the surrounding properties. And regarding G, it talks about screening and buffering. Again, we're not going to have standards for, you know, you have to have, you know, so many trees per linear feet of property line or anything like that. But we just want to make sure that they're not going to cause substantial impacts on the surrounding properties. And then again, number 11 has to do with the expiration that we talked about. And number 12 this is something that the fire people requested. It talks about the non-residential farm building activities. They have a specific code for that, for fire purposes. So this is the extent of how we propose that the county would be reviewing these activities.
Can you give me one example of an agritourism event that would have 1,000 attendees?
It could be, you know, people coming in to, you know, just spend the day in the farm and just be passive, looking at the cows and all that, or it could be 1,000 people that come in for a concert.
Well, if it's a concert, it's not agritourism. It's an event.
No, they are, they can be agritourism.
How's
They
that,
have-
how's
they have
a
justified them that
concert,
way.
how's a concert primary agricultural use?
It's a recreation that happens in a farm. I mean, there are so many ways that you can justify these things, but yeah, we have had difficulties with that because people say, but that's not related to agriculture. But you can make it relate to agriculture. Maybe it's folk music combined with rock, and all of
I
a
mean,
sudden it's a
We're-
farm activity.
We're seeking input from the Army Corps of Engineers for an agricultural, something that's protected by state statute. That seems overly burdensome.
Or letters of exemption, yeah.
Having dealt with the Corps, it's very difficult to get anything from them. But it seems like it's trying to address a workaround. I don't know, it just seems, like I said, overly burdensome for what agritourism is intended to be.
Can I just say, and I love all the work that you've done. I think it's very interesting. I think it raised a number of questions. I did not feel comfortable, and I did programming events for many years, and I can tell you this, everyone's unique.
Yep.
And knowledge and experience, like what we just talked about this morning, is when you start engaging all these other groups and saying, I want your approval to do this, fire, I want you to approve, police, I want you to approve, Swift Mud, you open them up to saying, no, because I don't want to take the responsibility. And so I think this is a great idea. I think the protection provided by the state is critical and valuable, but I don't think we know enough, and I am not comfortable when you say who's going to review it. If they haven't done it, if you don't have an expert saying, I know how many toilets you need, I know how long the schedule of programming is. If you don't know those things, I don't think you can make all these obligations to somebody. I just feel it's a reach for where we are today. That's my
Yeah.
opinion.
The problem is that the statutes tie your hands in terms of getting that information. We're not supposed to look into the operation of it.
I agree,
Per
but
state
then
statutes.
how do you make policy around stuff you don't know or can't ask?
We know what's going to happen on the outside by the demand of traffic, for example. How many cars are going to visit this place? That's what we care about, not so much
May I
whether.
humbly disagree and say, you can do events and have all kinds of talent, and people don't show up. You can do something like we did First Fridays out at Main Street, and when we first started, it was nothing. And then we added beer and cars, and it got to be monstrous. And so I think your analytical thought process is disrupted by the conduct of humans. That's my opinion. And events are an emotional commitment for daily. So I like the idea. I think it needs more thought, but I do think it's far-reaching to put it like this and think that programs follow that. I think that's difficult.
Anything else? Okay, thank you. Any closing comments or anything in summary from staff? Oh,
From staff?
yes.
You know, the way we see it is just the county's responsibility to address it. It's awesome that the owners of agricultural operations can open their farms and, do this agritourism, but the county has the responsibility to the people who live outside that site and the people who circulate through those areas. And we felt that this was the best way we could address that. Perfect, yeah, it's not perfect in the sense that the 1,000, like Nicole mentioned, it's not a scientific number, but it's not a number that will be set in stone forever and ever. It can be adjusted. And every situation, especially the definition of agritourism, because like you mentioned, Mr. Chairman, it's a wide, very wide definition. And we're trying to capture them all into one set of, review standards. And, you can start somewhere and then modify after that. But somebody mentioned, why do this now? It hasn't been a problem. Why should we do this now? And we were like, it's like the person who says, why should we put that pedestrian crossing there now? Why don't we wait until there is an accident?
I think that's the DOT's plan, by the way. Right? I mean, that's how they do it, right? After there's an event, they decide. Anyway, but not say they're right, right?
Yeah, exactly. All right, thank you.
All right.
Yes, sir.
Ms. Knapp, did you have anything?
Thank you again for the record, Nicole Knapp. I think Pat has summarized it quite well. I just wanted to say that, we don't plan to seek these types of uses to register with us. We're looking, a lot of this will come from if there's a complaint driven, and this just gives the county a process to address any complaints. Otherwise, our hands are kind of tied. So that's all I have to say.
I have a question you might be able to answer. The thing I'm struggling with, that, again, if there's something that's not related to primary agricultural use, it should be considered a special event and have to go through a separate process. Does the county have a process for that?
We do. We have temporary and special permit or special use permits for parades, marathons, those types of activities.
Yeah.
Christmas tree sales, all those types of ancillary uses that happen maybe once or twice a year on certain properties. But those aren't on farms. This is for people that have bona fide farms.
But doesn't the statute said that it's part of the primary agricultural function or something to that extent?
So, Mr. Connolly, with respect to, and this has been stated by Ms. Chayefsky as well, with respect to this does not regulate the agritourism activity taking place on site. I think the focus has been said, off-site impacts and regulating to make sure that the health, safety, and welfare of agritourism activities do not cause substantial impacts off-site.
Yeah.
And I think that's really the focus, and that's the way the ordinance is drafted.
Yeah, and I'm saying if it's not agritourism, if it's not related to agriculture, it's not agritourism, and the county would have the right to under the special event ordinance or whatever it might be, would have the ability to regulate it. I don't see how a concert is tied to agriculture.
So a concert in a vacuum, no, but a concert on, on a farm could be tied into agritourism. And I think that's kind of what you're dealing with, the way the statute's been written. We've provided, I think, and fostered a very conducive business environment for agricultural activities. We're fostering them, provided liability protection, and I think this legislature has expanded quite a bit what can be considered agritourism activities that are tied into agritourism. I think what this does is really try and provide, an ability to evaluate off-site impacts and to help evaluate any potential substantial impacts that could impact adversely health, safety, and welfare.
Right. In developing this, did the county attorney's office research if there had been any challenges to the state statutes?
So we did research, and we worked with staff, and we worked with the consultant.
Has this been challenged elsewhere? I know there were examples of other municipalities that have enforced this. Has that been challenged? Were there any challenges to the other municipalities? Yeah.
So I'm not aware of specifically, because I think with regard to Ms. Chayefsky's research, she mentioned Lee, Osceola,
Collier.
and I think, was it Collier or Escambia counties? So specific with those three, I don't recall. I've seen agritourism come up in litigation and case law for different reasons, not specifically, for an off-site impact analysis type of program.
Okay. All right.
Mr. Chair, I would think as a concert goer, what comes to mind would be like Farm Aid.
Yeah.
If the concert was promoting and supporting an industry, Save the Bees, a good death metal Save the Bees concert is something that is popular.
We
Yeah.
could all get into it.
Yeah.
But you could have the same event in a parking lot,
That's true.
True.
right?
You could.
Yeah.
But this is on a farm, so it's
Yeah.
different.
So, all right. I think I'll hold any further comments. Anybody else have anything necessary to make a?
It seems to me like code enforcement, or for Hunsagers, it would be State Road 64, which is a state road,
Okay.
that the DOT would regulate that kind of a thing
Yeah.
more than the county does. Or if the fire department drives by and they can't get in, I've seen them shut down other stuff
Yep.
or move cars off the lane. I don't know why we need another regulation to regulate stuff that we already have
Right.
regulated.
All right. I've been told this is a legislative matter, and we can have folks call in on this. So we have a couple callers on the line, is that correct?
Yes, sir.
So The first caller, if you could, please state your name and make your statement.
Caller 515.
Are you there?
Caller 515, please unmute your phone. Not unmuting, so.
Okay.
And the other one dropped off.
Okay, all right. All right, very good. So officially closed public comment portion of part 2. Anything further for the planning commission? Okay, we're going to close the public hearing part of this, and Chair will open it up to a motion, discussion, deliberation. So what's the
I'd
pleasure?
like to make a motion to deny or not recommend, let's see how they said this. Based on the staff report and evidence provided, public hearing is inconsistent with the comprehensive plan, and do not recommend support of the legislative amendment as submitted.
So we have a motion. Is there a second?
Second.
Second by Mr. DeLezline. Let's open this up for discussion.
I just think, I like the idea that we give the protection, but I do think it's far-reaching in saying we're not by state code permitted to reach into the agro process. And I understand about the external thing, but I agree that unless you've consulted people that have done a lot of these, that programmatically do this, or on committees or whatever, that we haven't done enough research to make this forward. I like it. I think you've done a lot of good work, but I don't think we're done. I think making all these commitments without further education would be less than productive, and I think there's obviously challenges that would be made by successful groups who are doing this currently. So I think at least we ought to know, we know 4 or 5 things that go on regularly, that this ought to be directly communicated with and get their advice. And I don't think that's a no, it's just I don't think this is the way we want to submit it. That's my opinion.
All right, any other opinions? I have an opinion on process. So I would think maybe the dialogue and discussion we've had have been maybe informative to the board and understand some of the issues. So I think it might be beneficial to send it to the board and allow them to have a same dialogue. And if they deem it necessary to extend it or send it back to staff, maybe that would be the more appropriate process. So we can, with the objections noted, send it to the board. So that would be another potential way to do this.
So with regard to the process, it will go forward to the board, but it'll be, if the motion as currently stated stands, it'll be found inconsistent with the comp plan, and the recommendation is of denial. And they'll see that.
Okay, all right. So what's the, any additional thoughts before we do call the matter to vote?
Yeah, I'd just like to say, I think the idea of growing our agritourism is a huge opportunity for us, and this is a great first step. And unfortunately, everything involves a learning process. And, you know, the idea of protecting our roadways and protecting accessibility is our primary goal. And the smaller events especially will give them the freedom to do what they're doing without the harassment of too much involvement of code enforcement or whatnot. If you're just doing a small wedding and a neighbor's upset and is trying to call code enforcement on you, suddenly it becomes an issue where code enforcement can say, sorry about your luck, but they're within the guidelines of agritourism. This gives us the ability to allow that freedom to at least start. There's learning curves and everything, and I'm willing to allow that to happen and see where we go with it.
Okay. And one of the things I'm struggling with, this seems like an attempt to fix workarounds of the rules, and it's overly burdensome. There's potential for those who are, it would be more appropriate to, might get caught up into the process. So that's kind of what I'm struggling with. And related to roadways, there's a very small portion of agricultural land adjacent to county roads. I mean, there are some areas you probably have to drive. They could be public roads. They may not be paved. You might have to drive miles before you get to an area. So I think it's, again, very narrow, very kind of reactionary for some past sins. So that's kind of my main concern. But with that, I'll call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign.
Aye.
Okay. All right. Chair votes aye. Motion passes 5-2. Thank you. All right. With that, we'll move on to the next item, item number 2, which is Manatee Port. I'm sorry, Port Authority, Manatee County. Ms. Slider, can you
Yes.
please read item 2 into the record? I'm sorry. Oh, yeah, I'm sorry. Thank you. So we're going to do two things. We're going to go ahead and open up for public comment. Is there anybody in the audience who wishes to come forward and make a comment on a future agenda item? Not on anything on today's agenda, but something in the future. Anyone at all? Seeing no one come forward, we're going to close the public comment portion of the hearing. And now the second order of business is going to be swearing in those who intend to speak on applications that are quasi-judicial. So if you intend to speak on an application that's quasi-judicial, please rise to be sworn in. If you don't do it now, you'll have to do it before you speak, and we'll make fun of you.
Do you swear or affirm that the factual statements and factual representations which you're about to present to the Planning Commission will be truthful and accurate? Thank you.
Very good, thank you. All right, item number 2. Ms. Slidar, can you read item number 2 into the record?
Yes, item number 2, PDPM 2110 CG, Port Authority, Manatee County, Port Manatee Master Development Plan, PLN 2104-0055. It's a quasi-judicial case and is for a rezone of more or less 9.9 acres in the northwest quadrant of a 1,112 acre size port facility from A1 suburban agriculture to PDPM Plan Development Port Manatee, and approving a master development plan for a total of 4 million square feet, 1,253,000 square feet are existing, and 2,746,000 additional square feet are proposing. Of port-related uses as listed by stipulation number 3 and accessory uses in the total acre of 1,112 acres, generally located south of the Hillsborough County line, east of the Tampa Bay, west of U.S. Highway 41, north and south of the state-owned conservation land in incorporated North Manatee County. The site is within the IH heavy industrial and IL light industrial future land use categories and the boundaries of the MDO Manufacturing Development Overlay District. And the case manager is Ms. Dorothy Rainey, and here is the applicant to present the case.
Very good, thank you. Have there been any ex parte communications regarding this application? No. Very good, thank you. Ms. Chadwick, good morning.
Good morning. There we go. We'll see if I can do the PowerPoint. I wasn't so good at this last week in Pinellas County, so. Good morning. My name is Diane Chadwick, and I am a planner with Stantec. I'm here today with Dan Fitzpatrick and George Eisenminger from Port Manatee. Okay. There we go. I'm going to start you off by orienting you to the property. I'm sure most of you know where the Port Manatee is. The white boundary on this map is the perimeter boundaries of the port, And as you can see in the green is the IH industrial heavy, which is the main portion of the active portion of the port. And then on the southern side, you have the IL, the light industrial. And a good part of that is either wetlands or conservation areas, but it is part of the port. Okay, here we go. So this is the zoning map. Again, you have the white boundary. It's a little bit more zoomed in here. And of course, the vast majority of the property is already zoned plan development Port Manatee. And I'm not sure if I have a way of doing this. What we'll talk about on the next slide, and I'm not sure you see, is the areas right up in here are the areas that need to be rezoned. But the vast majority of the port already has a plan development Port Manatee designation. This is more zoomed in to the areas that need to be rezoned. It's 9.9 acres. I think this is around 5 acres here and a little less than an acre here. And then this is on the north side of Piney Point, right at 2 acres, and then another additional acreage here. We really don't know why this wasn't zoned back in 2005 when the previous GDP was approved, but we discovered in our effort creating this master development plan that it was not zoned. So we are taking care of that now. So this is the aerial of the port with the boundaries in black. At this point, I kind of want to talk about the Manufacturing Competitiveness Act. I know there was a lot of information in your staff report. Dorothy did a really good job. I have to give her real kudos. This is a very different process, and she navigated through it and worked with us quite a bit. So we really, really appreciate that. But the Manufacturing Competitiveness Act was brought about to incentivize manufacturing industry and job growth in the state of Florida. It established sites with manufacturing uses, established sites for manufacturing uses and new development potential. And it also provided for the acknowledgement of ancillary uses that support manufacturing issues on those type sites. It created an expedited review process. It allows for any local jurisdiction, city or county within the state of Florida to adopt this legislation by establishing appropriate land areas for manufacturing. It establishes a manufacturing master development plan review process. It creates an approval process in land development codes, city or county, wherever it is. It allows the ability for a master development plan to come forward and for approved sites, and it proceeds to proceed to development without requiring any additional local approvals, and I'll explain that further later. It does require state permits, and it does require building permits, so that's very important that you know that. The process for this act does have oversight by the Florida Department of Economic Opportunity, which is considered the state land planning agency. DEO provides Manatee County's language to other cities and counties as a template. Manatee County was the first one to use it, and they do provide Manatee County's language as the template. So as the second part of this effort, I think I have my slides messed up here. Something's not. Okay, I'll just keep going. The second part of our effort is a request for the approval of a master development plan for the entire 1,112 acres, and that does include the 9.9 acres. The port currently does have a GDP that was approved in 2005, so it is still valid, but it is quite old. It is meant to function similar, this plan is meant to function very similar to the GDP. In fact, they look almost exactly alike. You I'm sure, have seen a lot of general development plans come through, so you would look at this and think it was the same thing, but it does have some nuances. I'm going to forward here because I think I'm going to. The staff report does go through lots of detail, and I'm actually not going to go through a lot of that because I know Dorothy's going to go through a lot of it, and I'm sure you have read through this. But the major components of the master development plan, we established that there was approximately 1.25 million square feet of existing, like I said, I'm off kilter here. I apologize.
We can start over if you. if it's-
Well, I seem to have my pages out of order. I keep going to looking at the slides and it's not working for me here. Let me back up a little bit here. Well, it doesn't want to back up.
You can use the mouse to back up.
Can you tell me which slide this is? I apologize, I'm sorry.
6.
It's 6? Okay, all right. Well, I'm going to go back to 5, if I can get it to go back to 5. There we go. That's where I want it to be. Wait, let's, yes.
I was joking
There
about
we
starting
go.
over, so-
There we go. I'm sorry. I apologize. Anyway, I'll start with this again, this is our second portion of our application today is the master development plan. But it does establish that 1.25 million square feet of existing square footage that sits at the port, and it does allow for that to be increased up to 4 million square feet. Basically, the ability to add 2.7 million square feet to the site. And that would include if a building was torn down, there's a constant tracking of that sort of stuff, but the maximum building allowed there would be 4 million. We established the permitted uses. The vast majority were pulled over from the general development plan. Very few changes to that. The required open space, it's only required, the plan development, Port Manatee really only requires 10%. We are providing 50% because of the large environmental area to the south. The setbacks and building heights were pulled over pretty much exactly the same. We did do a transportation study for this application, and it does allow for a 20-year concurrency approval time period. Some improvements were identified with that transportation study at certain trip thresholds. And those improvements have actually been identified on the master development plan. It's also important to note that Seaport Manatee already coordinates closely with FDOT for roadway improvements as they are a part of the strategic intermodal system. Now we go to this one. I'm going to keep moving on this. There was the incentivizing growth in the industry and job growth. The process has had oversight with DEO, and they do use Manatee County as an example for other areas. So now we'll keep moving. There. Just a little history on the Manufacturing Competitiveness Act. This idea was brought to Manatee County back in 2013 by Tropicana. I was lucky enough to have worked on that also. But the point was to make Florida more competitive for industrial facilities. Because Tropicana was a part of the PepsiCo brand, they saw many of their plant facilities in other states being able to move much faster than what places in Florida are allowed to move. So they went forward and created legislation. It is important to note that only 3 jurisdictions in Florida have taken advantage of this process. That is Manatee County, City of Bradenton, and Volusia County. Only 2 jurisdictions have moved forward with a master development plan. So that is Manatee County and the City of Bradenton, both for the benefit of Tropicana. And this will be the 3rd for the benefit of Seaport Manatee. Volusia County has, as far as we can tell, has not moved forward with any master development plan ordinance. But what it does do is ensure long-term viability for manufacturing facilities, and because it does have that 20-year time frame. There we go. And the way it is established is the county had to identify certain areas within the county to create a master development plan eligibility area. And you can see right down here is Tropicana. There's a site here at US 41 and 275, and of course the port sits right in here, but the vast majority of this eligibility area is in northwest Manatee. And the whole point was to create and incentivize industrial development within Manatee County. You have to have certain future land use categories of IL, IH, IU, or the Florida International Gateway, and also industrial zonings of the UI, and they all are planned development zonings. So you can see those listed there. Come on. There we go. Just as a point of reference, in 2019, Manatee County completed a study in regard to the Northwest Manatee area. It reviewed about 6,000 acres surrounding the port. The port itself was not part of that 6,000 acres, but it was the area around it. The report discussed the need to expedite permitting and create shovel-ready sites to attract industrial development to the county. And so many tools were discussed as to ways to create success with that. The Manufacturing Competitiveness Act, with that the Master Development Plan process, was just one of those tools identified. And Seaport Manatee, although their land area was not a part of that study, they did take part in the study, and they felt this was an excellent tool that they could use to promote expedited development within the port boundaries. So moving forward, we're asking for the rezone of 9.9 acres from A1 to PDPM, and we're asking for the approval of the Master Development Plan. And upon approval of the Master Plan by the Board of County Commissioners, new construction or redevelopment going forward would not require county site plan permitting. It would require a building permit. Let me repeat that. It still requires a building permit. It still requires state-level permits. Letters have actually been sent by DEO advising those agencies of this pending application, and I believe they're in your update packet. There's 5 or 6 of them. That tells them what their responsibilities are towards this legislation and how quickly they must move applications along. We are required continued coordination with county utilities and transportation. And the development sites will require a licensed engineer to do site design. Someone can't just go out there and build a building on raw land without taking into account stormwater and utility connections and those things that an engineer typically takes care of. And then that licensed engineer must attest that the design meets the criteria of the Master Development Plan. And most important, it allows support to move quickly on new projects. And with that, I will stop and let Dorothy take over, but we will be here to answer any questions you may have. And I apologize that my notes got out of order.
Ms. Chadwick, I have a question.
Oh, okay.
The Manatee County Manufacturing Development Program, the certification that's being sought, or I guess, has it been granted? Is that?
Has the program been granted? Yes.
Yes.
Yes. Back in
and-
2015.
Oh, I'm
It was
sorry.
adopted into your code.
Okay.
Yeah. It started in 2013. It took us 2 years to get it
Right.
through adoption. Yeah.
There are properties that are zoned PDMP that are properties owned by the port, is that
Yes.
correct?
Yes.
And there are similar uses adjacent
Yeah.
that are owned by private entities?
That's correct.
Can they benefit from the
Not,
certificate?
not this specific plan. They could file their own master development plan. That whole area in Northwest Manatee could file one big master development plan if they wish to do that. I would tell you that I think it's more difficult when you have multiple owners. Obviously, it was relatively easy for Tropicana. They own their entire sites. Many of you may or may not know, 2/3 of Tropicana plant is within the county, 1/3 is within the city. So we had to do dual process, and we made sure they matched up. But I have talked to multiple different jurisdictions over the last few years about this ordinance and whether or not it works for them. Most of them felt like that if there were multiple property owners, that it wasn't that easy to do. And I have to agree that it's not that it can't be done, but you have to have people willing to work together and agree to all the standards and stipulations. And for those of us who've been in the development industry, that's not always the easiest to make happen. But it is certainly possible, yes. So that whole red area on northern, right up at the north boundary of the county could all be a master development plan. They would just have to come forward and file that and set the standards with the county staff.
And the benefit, the overriding benefit is a streamlining process?
Very much so. That is you do not go through the county process. You don't avoid the state agencies, but they have a much more condensed timeframe in which they have to review your plans. They can't, I know that you know, sometimes it's very painful how long those agencies take, and they will not be allowed to do that anymore. They have to move quickly.
Okay,
Or give reasons why they're not moving quickly.
okay, very good, thank you.
All right.
Mr. DeLesling.
Does the port own all the property in Port Manatee, or is that leased out to individuals for construction, or
The boundaries we showed you here, the port owns all of that land.
then like Del Monte owns the building but not the land?
Perhaps either George or Dan can come and answer that. I don't know exactly how they do the buildings. I assume they're ground leases, but I'm not sure.
Good morning. If you would state your name and that you have been sworn.
Thank you, Dan Fitzpatrick. I have been sworn.
Thank you.
Thank you. Director of Planning and Development at Seaport Manatee. And I believe the question was, do companies that operate at Seaport Manatee own the land? And no, Manatee County Port Authority owns the land. And in the case of Del Monte, I believe the land is leased.
Okay.
Thank
That's why I
you.
was curious.
Okay, thank you. Any additional questions for the applicant? Okay, thank you very much. Now for staff, Ms. Rainey.
Good morning, Dorothy Rainey for staff, and I have been sworn.
Thank you.
I'm not going to have anything new or additional to what Diane presented to you, but I'll go through it quickly. So the request before you, as was mentioned, is approval of a rezone of 9.9 acres that still remain A-zoned to Plan Development Port Manatee to be in conformance with the rest of the port property, and approval of a master development plan pursuant to the state statutes and all that Diane went over, and the manufacturing program. So also approval of an increase to the total square footage, as was mentioned, to a maximum total of 4 million square feet. And then it's retaining the schedule of uses as well as bulk and dimensional requirements from the previous approved GDP. Future land use, as was mentioned, it's mostly heavy industrial in the black, and then there's a little boot there that's light industrial. And as was mentioned, it's mostly conservation lands. The zoning, whoa, I didn't do that. Sorry about that. What's happening? A ghost in the machine. Okay. The zoning is all planned development Port Manatee with the exception of the 9.9 acres, which is part of the request in order to rezone it to PDPM. Here's an aerial of the site. I didn't have a very good just site plan showing existing and then where the vacant spaces are, so this aerial is probably the best one to get an idea of where there's vacant undeveloped land remaining for that the 2-point-something million square feet. So the surrounding uses to the north is the Hillsborough County line, as well as A1 zoned large parcel residential properties and some vacant land owned by Tampa Electric. To the south is conservation lands zoned CON, and it's owned by State of Florida, as well as some PDEZ zone property owned by U.S. Funding Group, LLC. It's vacant and industrial. And to the east is the PDPM zone property owned by the Port LLC, Port Manatee LLC with agricultural uses, heavy manufacturing zone property with ag uses with grazing, as well as US Highway 41 right-of-way. And then to the west is conservation lands owned by the state, again, and the Tampa Bay itself. Again, it's 1,112.9 acres total, zone PDPM with the exception of the 9.9 acres that's A1. In heavy industrial as well as light industrial future land use categories, as you saw. And it's located south of Hillsborough County line, east of Tampa Bay, west of 41, and a bit north of 275. There's the site plan, not too clear, but just to get a bit of an idea of where the existing buildings and structures are. Access points, there's two existing access points, one off South Dock Street and one off Piney Point Road. There's multiple existing uses, of course, and approximately 556 acres of the entire site are open space and conservation. The positives, of course, are that there are no changes to previously approved permitted uses, dimensional criteria such as setbacks, building height, buffers, and open space, parking, utilities, stormwater facilities, and required improvements are proposed with, no changes are proposed to the with this master development plan. The application does comply with all the regulations of the Manatee County Manufacturing Development Program, and this approval will provide for viability of the long-term existence of the port with allowing expansion established pursuant to the Manufacturing Development Program. Negatives, the approval of the master development plan will allow development projects to forgo the usual final site plan review and approval process, and they'll go straight to building permit stage. However, the building permit review process may provide an opportunity for reviewers that would normally review a project with the final site plan to do a review with the building permits to ensure the project will meet their requirements. So when permits come in, they get routed to various public works entities that can review for utilities and for other infrastructure requirements for the projects that come in. So we conclude that the request may be found to be in compliance with the requirements of both the comprehensive plan and the land development code, and of course with the manufacturing program that they've applied for. And that's all I have. Thank you.
Very good. One question for you. There are some adjacent properties that are zone PDEZ, plan development enterprise zone, is that what it is?
Encouragement zone?
Encouragement
Yeah.
zone?
Mhm.
What's the difference between that and, well, I know the PDMP is property owned by the port and falls under
Right.
that. What's the?
Yeah, the encouragement zone was established in 4 separate quadrants with 4 separate PDEZ ordinances with their own specific list of uses that are allowable, and then the bulk and dimensional requirements like setbacks and things like that. And they're privately owned property, and the owners chose to participate or not participate. In fact, all 4 of those ordinances have probably been amended 2 or 3 times or more to add new property owners that want to be in it. And it just affords a little bit more, I guess, ease of developing. Again, it's an encouragement zone, mainly to encourage port-related or port-dependent uses for the most part.
But specifically to support activities associated with the port?
Yes, with the
Okay.
port, yeah, that
All right.
need to be located near it, that sort of thing.
Okay, thank you.
Commissioner, sorry.
Yes, ma'am.
The other change is, the other important thing is that this plan is subject to the requirement that they don't need to go to final site plan. They have to go direct to building permits.
Okay,
It's different to the PDEC, they have to go to
Yeah.
their general process.
okay, all right, very good. And Ms. Rainey, one additional clarification for me. When we talk about 4 million square feet, plus or minus, is that a result of the floor area ratio, or how does that come about?
I believe the floor area ratio is probably, I would think it's probably 1.0. I have to look. Well, it's dictated by the heavy industrial and light industrial. I don't have that in
But
here,
it's,
but it's in the staff report, right, Rosina, for the
Is it blended across the site, or is it separate with a combination, a total of 4 million within?
It's a combination of the total potential square footage, and the proposed floor area ratio is way below to the maximum and possible is 0.08, and the maximum that is possible to build is 0.75, given the future land use categories.
Okay,
Okay.
okay, all right, thank you.
Thanks.
Thank you. Anything additional for staff?
Just a question, the 9.9 acres, do you know why that wasn't rezoned to PD?
No, I don't think Diane knew either. Just
She didn't.
housekeeping
I
that
just wondered if you
didn't get taken care of at some point, yeah.
Okay.
Okay,
Can I ask one question?
sure.
Is there any concern whatsoever to go from 1.2 acres to 4 million square feet, 1.2 million square feet to 4 million square feet? Like, it seems like you brought it in to say, okay, we're rezoning 9 acres, but by the way, we're lopping you into a thing that makes it so you can develop 4 million square feet.
Well, being that it's a master development plan, it's basically their wish list, if you will, and this is the maximum we're ever going to ask for. And there was land available to develop, and the floor area ratio, as Rosina mentioned, they're way, way below that. So even with the 4 million. So.
Let me ask the question in a different way that might be helpful.
Okay.
The previous number, the previous number, the million plus square feet, that didn't presume utilization of all the land that was
No.
within the master plan.
No.
So this is this a, I don't want to provide testimony, I want to ask a question. Is this looking forward in, the master plan? It's what it could be over the next 20 years?
Yeah, definitely. They had to ask for the maximum because this is it. This is their approval for 20 years. So, and they're able to, bypass that final site plan process to build up to 4 million.
And had we not done the master plan, it would still be an incremental increase, probably to the same number, but this is,
Right.
again, looking forward, master planning, of course, with the master plan, what it could be.
Yes, that would
Okay, all
most
right.
likely, yeah. Mhm.
Got it. Yes, ma'am.
Regarding your question on surrounding properties.
Yes, ma'am.
Under the state statute. The state statute requires that the property owner have queued up a manufacturer before they go to the state to qualify to go to this
Okay.
master plan. So it can't just be a group of property owners getting together.
Yes.
I think that the holdup is probably having the manufacturer queued up to
Okay,
participate.
so, okay, understood, very good. Thank you. All right, anything further for staff?
So I just had, again, kind of one
Question
question.
is that, so yeah, this is the last time for 20 years until they come back again. I mean, that's kind of how it works, right? I mean, so when we say this is their plan for 20 years, it's like 20 years until we find out something different, so, which is okay. My question really is there some basis in fact or performance or success or development that's occurred that makes this the new reasonable expectation at 4 million square feet? Is there I understand there's some significant volumes changes at the port, and there's some significant, so my question really is there some expectation you get to 4 million square feet, or is this the engineer's maximum calculation?
I would say that question would be best answered by the applicant.
Yeah, well-
Since they've done their homework and their study on the trends and, the popularity of the port as a location, a destination for many manufacturers and, distributors, that sort of thing.
Yes, Ms. Chadwick, if you could maybe just describe what the impetus was for taking this route.
We looked at a lot of factors. This is Diane Chadwick, Stantec. We did look at a lot of factors. The port, not to be confused with the master development plan, but there is such a thing called the Port Master Plan, which they update, like, I think it's every 5 years. That Port Master Plan identified uses and square footages. We looked at that. We looked at the projections of what they are, what the port is seeing coming in interest, and what we thought was the potential for real building there. There's a lot of land there that doesn't have buildings on it, but it has stockpiles and different things. So yes, we could have asked for a whole lot more, but chose not to because we felt the 4 million square feet was a reasonable projection of what to expect in the next 20 years. If for some reason they become uber successful, they could always come back here and ask you to update this master development plan and ask for more square footage. But there wasn't a list of uses that we're projecting this many square feet for each of these uses for how we got to that 4 million. It really had to do with the port master plan and what they know as far as projections for their own port operations.
And does the Port Authority report to the commission, the board?
Port Authority is the board.
That's who sits as the
They
board.
change hats.
Perfect.
That works well.
Does it? Okay, if you say so. It's good.
And just additional clarification, the Port of Manatee, the property owned is actually county property in a roundabout way.
In the roundabout way, yeah.
We, the taxpayers. Thanks.
And that's the whole reason for this, is to lessen that burden. Yeah, very
No,
good.
no, it's-
All right, anything further? I'm going to go ahead and go to public comment if we have nothing further. So with that, I'll open it up to anybody in the audience who wishes to come forward and make a comment, statement, or ask a question regarding this application. Anybody at all? Seeing no one come forward, I'll close public comment. Any additional questions for staff? Last chance. Okay. Staff closing comments? Any questions for the applicant? We'll go to applicant rebuttal and close the public testimony if that's the case. So applicant rebuttal? Or closing comments?
George Eismayer just corrected me that it is Port Authority-owned land. It is not Manatee County land. So I just want to make sure we make that clarification.
All right, and with that, is that how is that, if the county commission,
All right, tell me, who owns it? Come on.
oh, I have a,
We'll let the expert answer that.
County owns the Port Authority.
Hi, George Eisenmenger, Port Manatee. I'll describe it as I understand it. So the port
There's
is
no hope
run
for us.
by the Manatee County Port Authority, which is the county commissioners, and as Diane said, they wear different hats. Different one is chairman. And it's a special district of the state
oh, okay.
and owns property separately from anybody else, including the county.
Right,
And all that land is owned by the Port Authority.
so it's a quasi-governmental entity?
Yes.
Very good, got it. Thank you. All right, with that, I'm going to close the public testimony and public hearing and open it up for discussion, deliberation, or entertain a motion.
Mr. Chair, I'll make a motion.
Mr. Ron.
Based upon the staff report, evidence presented, comments made at the public hearing, and finding the request to be consistent with the Manatee County Comprehensive Plan and the Manatee County Land Development Code as stipulated herein, I move to recommend adoption of Manatee County zoning ordinance number PD-PM 2110ZG and approval of the general development plan to serve as the master development plan with stipulations A1 through A11, B1 through B5, and C1.
Very good, we have a motion. Is there a second?
Second.
Second by Mr. Smock. You shaved your beard, I didn't recognize you.
Just trimmed it up.
Trimmed it, I mean, yeah. All right, we have a motion, a second. Any discussion? All right, with that, we'll call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye, motion passes 7-0. And with that, I'm going to call a break. Let's take a break until 10:45. Thank you.
They really don't think, they're only concerned with their own selves. And of course, there's a lot of us older people as well, who don't know where they're going either, or want to. That was it, 8 minutes, get back. That's okay with me.
All right, if you could please make your way back.
Rutledge is the only one?
Go ahead and keep this, on the road.
We have a quorum.
Sorry, let's go ahead and reconvene the meeting. With that, Ms. Lidar, can you please introduce item number 3 into the record?
Yes. PDMU 2115 CG Circa Italia, 53rd Avenue East, rezone Invest PI LLC owner, PLN 2108-0028. And this is a quasi-judicial case. It's a rezone of 2 parcels of more or less 5.66 acres from Pier M Professional Office Medium and RSF 6 Residential Single Family Zoning District to the PDMU Plan Development Mixed Use Zoning District, retaining the Southwest Task Incremental Financial District designation. The site is generally located 775 feet from the intersection of 15th Street East and 53rd Avenue East at 1623 53rd Avenue East, Bradenton, Manatee County. Also is the approving a general development plan for a 2-story multi-use building having 20,000 square feet office, commercial, and up to 8 multifamily residential units, and a 52,000 square feet performance area consisting of 12,800 square feet entry concession tent, a 20,345 square feet performance tents, and grass parking area for medium intensity recreational use, and approving a schedule of permitted and prohibited uses at voluntary profit by the applicant. The case manager is Marshall Robinson, and here representing the applicant is Mr. Scott Rudosil.
Good morning, Mr. Rudisil. Before you get started, any ex parte communications to disclose from the board or the commission? Sorry. Very good. Thank you. Good morning, Mr. Rudisil.
All right. Good morning, Mr. Chairman, Commissioners. For the record, I'm Scott Rudisil with Blaylock Walters. I'm here on behalf of the applicant. I'm going to briefly introduce our project team. We have Manuel Rebecki, who is the property owner for the site. Cameron Miller is our project planner with ZNS. Nathan Crott is our engineer, also with ZNS. And then Michael Yates with Palm Traffic is the traffic engineer on the project. All right, this is an aerial of the site. It's approximately 5.7 acres located on State Road 70 East, just east of the intersection with 15th Street East. And State Road 70 in this location is a 6-lane major arterial roadway. This is a picture of the site. It's the former Onico Glass property. We'll go back for those that remember what it looked like before my client purchased it. That was what it looked like when it was operating. In fact, when my client acquired the property, there were some folks living in the building in the front there, the red building. There were some folks also living in the wooded area behind the property. That red building has now been removed.
Agritourism?
Yeah.
So looking this is the property fronting on State Road 70 that is east of the site. It looks like some kind of outdoor storage type of use. And then to the west is actually vacant property owned by DOT. So, we hear a lot about wanting to encourage redevelopment and infill development in the county. And this is an area of the county that has not seen a lot of redevelopment interest. This is a true redevelopment and infill project. The request that's before you is to rezone the site from PRM and RSF 6 to plan development mixed use with a general development plan for a 20,000 square foot building, 2 stories on State Road 70 that would be a mix of retail, office, and then up to potentially 8 residential units. And then to the rear of that building is proposed a grassed area with temporary medium intensity recreational uses. So let's talk about those for a little bit. This is it's proposed for the Circa Italia use. For those of you who have not been, apologies to Mr. Rutledge, there are no lions. There's also no coleslaw wrestling or death metal Save the Bees concerts. They don't have that either. This is it's a Cirque du Soleil style performance venue, and so that's what the nature of the use is within an enclosed tent. And so in terms of timing, we have proposed a maximum of 40 days per year. And so I want everybody to understand what that looks like as it plays out during the year. At any one time that the show would be on the site, you would have a maximum 20-day temporary use permit that would be issued. So that 20 days would be your setup, and then the performances. So you're essentially going to have two weekends of performances, and then you have the takedown all happening within that 20 days. So when we say 40 days, you're going to have 2 times per year that the show could potentially be on the site, and really only a handful of days out of the year that you would actually have patrons there at the facility. So this is a show that's been operating within the Riviera Dunes community for the last several years without issue there. So we think it's a good use for that back portion of the site on a limited basis. And with that, I'm going to turn it over to Cameron for the planning issues.
Good morning.
Good morning, Cameron Miller. I'm a planner with ZNS Engineering, and I have been sworn.
Thank you.
So I just have a few slides here regarding the land use, zoning, and then the general development plan as a whole. Here you can see the property on the portion fronting 53rd Avenue East. It is in the ROR, future land use category, and that northern portion is in the RES-9. Also, I've delineated a part of that activity node that is at the intersection of 15th Street as well as 53rd Ave, and the one farther to the east for 301 and 53rd Ave. I do also want to point out that this is within the urban service area under Map K of the comprehensive plan. That is some language in that plan that highlights and encourages development and infill development, which I believe this project is meeting some of those goals. Onto the zoning map, we have a little bit more of a focused view on the project site. As you can see, the southern portion is in the PRM, and then that northern portion is in the RSF-6. And as you can see, further to the north and to the west, we see heavier manufacturing or intensive industrial uses, as well as more general commercial and heavy commercial to the west. Moving on to the general development plan, here's a colored depiction of it off on the right-hand side. Like Scott mentioned, roughly 5.7 acres. The southern portion, 1.5 acres, is proposed as mixed-use development. The density is 3.3 dwelling units per acre, and the floor area ratio is 0.25, so meeting the requirements there. On the northern portion, it is the remaining 4.16 acres. Approximately 52,000 square feet is going to be used or delineated for the performance area. That calculates for a floor area ratio of 0.29. For the open space requirements, we're far exceeding those expectations because we plan to utilize those grass areas to the north to be kept as grass. So for year-round use, it will be more green space, and we feel like that's a better use than just a standalone parking lot there. Moving on to the screening buffers, we are exceeding that requirement as well. A 10-foot screening buffer is required between recreational uses and a residential use. We are providing 20 feet. That is per section 7-4 in Chapter 7 of the Land Development Code. That is about all I have regarding the general development plan. I did just want to note that we believe that this is a good project for redevelopment, especially facing 53rd Ave with a true mixed-use development, and also meeting those infill development goals that the county has put in place. So thank you very much. I'll hand it back to Scott.
Thank you, Cameron. I'm just going to touch on the specific approval requests here, and then also some of the stipulations, then we'll wrap it up. So we have 3 specific approval requests for the project. They are all related to the grass parking area. They relate to landscape islands, vehicle use, planting areas, wheel stops, things that you typically, that are in the code, so you don't have a sea of asphalt for your parking area. We have a sea of grass, so we think that's a better use for that, and staff's in agreement, and that's why we've requested those. We've also included several stipulations to further limit the temporary recreation uses. We have a max performance seating of 400 seats. We already talked about the maximum number of days per year, which is 40, so you have approximately 90% of the time this area is going to be just grassed open space. Maximum number of days for any event is 20 days. We had proffered a stipulation for no alcoholic beverage sales on site. It sounds like there may be a concern with that, but that is certainly something that the applicant is willing to stipulate to. There was a request to stipulate for no outdoor storage on site. The applicant is happy to do that as well, so that it will remain grassed open space for all the time of the year that it's not in use for the rec use. And then there's a stipulation about no overnight stay, and the applicant is in agreement with that as well. That was one that was added in your update, so the applicant is in agreement there. With that, I'm happy to answer any questions that you have. We're respectfully requesting a recommendation of approval. Thank you.
Very good. I have a couple questions. The intent is to have a circus tent for performances, is that correct?
Correct, yes.
What is the height related to the structure, even if it is a temporary structure that would be on the site?
That's right. So I think the max height of the tent is 53 feet.
How is that consistent with what would be allowed under a permanent structure in the zoning district?
Yes, we'll have to meet the requirements for the step back as the additional setbacks as with the height. So we'll have to meet all of your standard code requirements related to the height of the tent.
And the buffering would be provided consistent with if it were a permanent structure?
That's correct.
Okay. And then I think the reference to events, does that include practice?
Yes, so that includes setup, practice, the events, takedown. Okay. The whole thing is within that 20-day period.
Okay. And a lot of the focus has been on the circus component of it, but there is an additional element to this, correct? Is there a proposed commercial building at the front?
Yes, absolutely. So there is that is a redevelopment of that building in the front that'll be removed completely, and it is proposed as a 2-story, 20,000 square foot with a 10,000 square foot footprint, retail, office, and then up to 8 units of residential.
Okay. Just reviewing the site plan, it looks like there maybe is a connection to the property to the east. Is that correct?
We have provided for a potential future cross-access with the commercial property to the east, yes.
Okay. Have a couple questions related to traffic, if that would be okay. Good morning.
Good morning. Good morning, Michael Yates with Palm Traffic, and I have been sworn.
Thank you. State Road, or 53rd is also State Road 70, which is a DOT roadway, correct?
Correct.
Has there been any discussion with DOT related to the access?
There has. We did a pre-app back in December with DOT. They had some concerns about the access configuration and 2 access points. We originally had the retail building. If I can show you real quick.
Sure.
So just a blow up of the driveway configuration and everything. So this is the retail building right here. And so it originally was on the eastern property line. And so what we did was we moved it over to the western side of this line here. This is a DOT pond in the middle. And so what we did was moved it over to the west, and then we provide the cross-access stub out to the property to the east. And so this is a DOT roadway, and so based on their DOT classification and the posted speed limit, connection spacing is 245 feet. This gets us within the 245 with the exception of the space between the driveways. And so we've submitted this back to DOT, and they are reviewing this as it has been revised.
Okay, very good. And then maybe if I could ask the engineer a couple of questions. Oh, I'm sorry, Mr. Yates.
One more question.
Sorry.
17th Street East looks like it comes onto the property site there. Is that going to be used for ingress and egress for people coming in off the site or for any type of traffic going up and down 17th Street East?
Are you looking at 16th Street East?
Well, it's at 51st Avenue East is a public road. And it looks like that there's a street there, 17th Street East. It looks like it like comes onto the site.
So there is a private road adjacent to the site.
Yeah.
That serves a couple of residential uses. And it is my understanding that will remain as it is, a private roadway that serves a couple of the residential uses. I know there was some discussion back and forth with staff about trying to combine those. As of now, they needed to be separated. And so we're working through that issue with DOT on the connection.
Okay, I see that where it says private road, but there's 51st Avenue East is a public road.
I think he's asking, does all traffic
Yeah.
leave out State Road 70?
All traffic will leave out State Road 70.
All right.
Yes, they will use these 2 access points.
Okay, thank
on
you.
State Road 70.
Okay.
And they are right in, right out.
Okay, thank you.
Right, and if I could just add on to that, there's a, Bully's Creek runs through the middle of this, so I don't think we discussed that. And everything that is proposed for the grassed area is all south of Bully's Creek, so there's nothing proposed on the northern portion of the site whatsoever.
All right, cool, thank you.
Thank you.
Can we talk about vehicles? Parking?
Which,
Approximately how many spaces are you going to have for every event?
We have, how much? 190.
And the attendance?
No.
can you, when you do give the information, can you make a distinction between paved spaces and grass spaces?
Right. Okay, so he's saying the requirement's 134, we're providing 128, which is within the 10% that can be requested.
And those are all paved spaces?
No, those are the grass spaces. Right.
Okay.
So we anticipate that we'll have use of some or all of the paved spaces as well.
Okay. With that understanding, is there a distinction between hours of operation that would be presumed for any event?
Are you talking about with respect to the commercial
No, I'm sorry.
uses? Oh, just generally?
With the statement that you expect there would be opportunities to utilize the commercial spaces for any event.
Right. At this point, we don't know what's going into that building. So, I think it's unclear right now what the ultimate hours of operation or tenants will be there, so.
Okay. And then,
Go ahead.
I'm sorry, I was going to ask about Bowleys and floodplain. So, Mr. Kratt. Good morning.
Good morning. Nathan Crott with ZNS Engineering.
Thank you.
I have been sworn.
Thank you. Just reviewing the GDP that was provided, I think it was a GDP, wasn't it? There's a sheet that has the floodplain delineated. Have you looked or done any analysis that would lead you to be able to address what the impact of the development might be with regard to the existing floodplain?
Yes, sir. We have worked with Mr. Gerstenberger as far as the latest available information. So there is a Bowleys Creek watershed model that's available for this. And the floodplain is actually contained within the creek itself, within the top of bank. And so the site itself, the parking area is actually, will not be located within the floodplain. We have no intent to fill it. And so, regardless, there would be no impact to the floodplain with this grass parking area.
You're saying there's no impact to the floodplain? Can you put up the FEMA floodplain delineation that was included in the application, or at least in our package?
So can you guys see that?
I might be misreading the legend, but.
So right here, this is based off of the Bowleys Creek watershed model, which is the latest and greatest watershed information available. Okay, I think what you're referring to is what Marshall just brought up, which is the FEMA. Okay, and so this is your floodway line, and this is your floodplain. We would go off of the latest available information, which would trump the FEMA. Maybe Mr. Gerstenberger can speak a little bit more to that, but I think, honestly, it doesn't really matter. We have no intentions of filling the parking lot. There will be no impact to the floodplain. It will be at grade. If for some reason there was an elevated parking drive aisle or parking space, we would then offset that with some type of compensation area. Does that better answer your question?
Yes, I think some additional discussion related to the Bowleys might be necessary. I didn't notice any treatment or attenuation being proposed. Why is that?
So the intention here is there is already impervious area on the site, and so that's already credited towards what we can propose as far as new impervious area. Anything over and above what's already there, we would then have to treat and compensate for. That is not the intent, is to go over that. So if we did, we would then in fact provide that stormwater treatment and attenuation.
Okay, all right, thank you.
Is your question more like, will this flood?
Not really.
Events going on?
No, it's more in the 100-year condition, what happens, the unusual event, not the typical event, so.
We do have, there's stream gauge data and we have results, and actually I brought some pictures from the 2018 no-name storm event, all contained within the top of bank. So it's pretty well documented that that Bowleys Creek in this area does not overtop its banks.
You have Gerstenberger's stamp of approval.
That's what I'm saying. You got it. Now, I think he's here. I'd rather have him say that, but.
Okay, very good. Any other,
Yes.
Mr. Ruff?
Hours of engagement. Do you have any idea when this thing opens and closes during the day?
No, I don't. They have, my understanding is there's like a matinee show and then late afternoon and then an evening.
Be more specific. Will it conflict with traffic at peak hours?
We had a traffic analysis that was submitted and they looked at it as if this was going to be a full-time operating theater, essentially, as the use. And staff reviewed that, and I think it was something like 50 peak hour trips with the theater, 400-seat theater in operation.
And the staff has approved of that?
We'll get a staff,
Okay.
we'll get staff
Yeah.
presentation next step.
Sure.
Thank you.
Very good. Any additional questions for?
Can I ask, the 8 residential units on the second floor, are they intended for people related to the recreational use or just completely unrelated, or?
Right, I don't know the answer to that. We have had some discussion about how that might be a possibility to use 1 or 2 of the units for that,
So they
that
might
type
not
of.
be occupied all the time?
Right, that's possible.
And then the lower floor, the commercial space, also not determined if it's going to be related to the circus or recreational use?
Correct. My expectation is that it won't be, just independent retail office type of use there.
Okay.
How about noise and volumes and stuff like that? Due to the circus, I guess, commercial buildings really
Right.
not that big of a deal.
Well, again, I mean, this is all, first of all, we're going to have to comply with all the county's noise regulations. And in this area, you're going to be dealing with the residential restrictions on that. So we're going to have to comply with that. All of the use is enclosed within the tent structure. So it's not like an outdoor, festival or something like that. So it does a better job of keeping that.
Yeah, but
keeping
it's
that
still
enclosed.
a tent though, as opposed to a building.
Right, understood. But like I said, we will have to comply with all the county's noise regulations for off-site noise impact on those residential areas.
And lighting too, I guess?
Correct, yep. And that'll all be reviewed. We're going to have to, in addition to this, the applicant will have to come in for a temporary use permit for every time they do one of these shows, and it's going to get reviewed again at that point by all the staff, and they will be able to address any individual issues there.
Mr. Rudisell, I wanted to kind of elaborate a bit on that stipulation 8 regarding the prohibition of alcohol sales and kind of elaborate on that.
Sure.
So the concern is the county potentially regulating this via stipulation in a zoning ordinance and potentially enforcement of that. Would the applicant consider, rather than doing this in a stipulation, would they rather maybe amend the proffered list of uses to strike alcohol beverage sales altogether? I think that would be a cleaner way and an effective way of addressing that.
If we could do that in a way that would limit that to the recreational use area, I think that would be fine. The only concern that I'm having in my mind is, you could have a restaurant or something in that building up front, the retail office. So we wouldn't want to prohibit that on the actual residential, on the commercial.
Well,
piece.
alternatively, then I think there would have to be some way in order to kind of indicate that the county is not regulating whether someone walks out of that front end portion with a drink and walks to the tented portion with that drink in their hand.
Sure.
I don't know if that could be addressed via the GDP, a note, or some way, but I think that's really the concern.
Okay, and we did have some discussions with staff here just earlier today. I think we can work through those issues between Planning Commission and the board. But I think we're in agreement conceptually.
Just a point of clarification, though, if you walk out of a restaurant, probably can't hear me. If you walk out of a restaurant with alcohol and you're not in a wet street, you're in breach of that licensee, correct? I mean, so they can't, what you just said they would do, maybe they would do, but they're not allowed to do anyway by license, right?
So it's not really my deep area of expertise, but they could simply walk out of the office building, it's still on site, and walk towards the tented area with a drink. And so I mean.
But if there's no statutory conduct prohibition, to say that people don't do things.
I wanted to be clear that the county is not regulating that, meaning that's kind of the state. That's their thing. That's the licensing that they do. So.
And I want to be clear that the applicant has no intent of doing what you just described, so.
Okay.
All right. Any other questions for the applicant? Okay, thank you. We're going to go ahead and go to staff presentation.
Good morning, everyone. Marshall Robinson, staff planner, and I have been sworn. Mr. Rudisil did a good job of covering most of our information we're talking about today. The location of the property is on 53rd Avenue. We're just going to wait for the PowerPoint to get full in effect here. Here we go. So, yeah, we're talking about 53rd Avenue, or State Road 70, for the location of the property. The property is in two future land use categories. Up along the major arterial roadway of 53rd Avenue, we have that pink area there. That's the ROR, or Retail Residential Office Future Land Use category. And then north on the site, we also have this brown area, which is the Res 9, and that's a Res 9 Future Land Use designation. And the zoning for the property, currently out there right now, we have professional office medium and residential, single-family residential zoning, and we also have the Southwest Tax Incremental Financing District. And they're proposing to do a plan, mixed-use plan development and retain the TIF district within their project. And the request is elaborated earlier. They are asking for temporary medium intensity recreational uses, and they're also asking for the two-story mixed-use building that would have office, commercial, and residential components to it. Mr. Rudisil elaborated on the intensity and density of those uses in terms of square footage and number of units. Here's a look at the site plan. Put this map together in your staff report. Hopefully it graphically kind of represents some of the treatments that were required and also offered by the applicant. Most notably here on this map is the FDOT parcel that's kind of the horseshoe in the center of their frontage. They don't own that property. That's an FDOT-owned, I think, stormwater facility. We have access here on 53rd Avenue. As the applicant pointed out, the access is subject to FDOT approval. It's not owned or maintained or in the county jurisdiction. Moving throughout the site, we see down on the bottom right-hand portion of the site where the existing building that's currently on site will be removed and replaced with new construction for the two-story mixed-use building. Also, you can see in the design of the GDP, we're going to be able to get a little bit of extra separation with the vehicle use areas and the parking that separate the building and the properties to the east along that boundary. Moving your eyes north up the site plan here, we see that internal vehicle use area network that serves the parking. And then we transition out of the ROR, and keep in mind, our map says that, you know, the south end of the property or along the road frontage is the ROR where the intensity and the residential mix of uses can occur. But then as you get north to the property, we get into that kind of that sea of residential land use designations out here. And it's important to point out, and I probably should have done this maybe in the PowerPoint, but I would like to point out a map that's in the staff report. Here we go. Can we get the Elmo up, please? So I just wanted to point this map out to take a look at the development pattern in the area. You'll see the two circles, and that denotes what we would qualify as an activity node or a commercial activity node, and this project is located in between two of those nodes. So I just wanted to point out the pattern here for the ROR future land use districts. It runs in a north-south fashion, but you can see that finger that comes out within the activity node, grabs the ROR and the road frontage, and that's where the mix of uses is proposed. But north of that, we also see that the Res 9 is within that activity node. We see that the Res 9 actually falls in a location where, you know, mixes of uses and things like that and increased densities and intensities can occur. So I just point that out to say that while we are talking about the Res 9, we're talking about a Res 9 property that's within an activity node, commercially speaking. Even though it's a medium intensity recreational use and not commercial by definition, I just want to point out the fact that this is where those non-typical uses in the future land use category are really intended to go. And then I'll just get off that map. Can I get back to the PowerPoint? Thank you. And this is kind of a more cleaner look at that future land use map. Getting back over, working off the site plan here, for this property, or this, for this use, the medium intensity recreational use, they are, as Scott, Mr. Rudisil pointed out, 10 feet is required of buffering. They offered 20 feet of buffering, so they exceeded the minimum setback for that requirement. When you take a look at the setback that they proposed, it does meet our 401.5 building height compatibility requirements. That requirement is based on stories. We measure building height in stories, not feet. However, you are required to provide additional separation for every story above 3 that you go. So if you do the math on the height that they proposed at 53 feet, and I will add that they do propose to go up to as high as 71 feet if you were to include their flags. They have flags that, kind of go around the tent. So we're talking about two different heights here. The 53-foot height for the tent structure itself and the 50-foot setback, we do seem to meet the minimum requirements of the 401.5, where you provide 20 feet of extra separation in addition to the minimum requirement for every story above 3. So if you do the quick and dirty math, the 50-foot setback gets us there on the 53-foot structure. And then we also have it in the staff report that at the time of final site plan, that they would have to demonstrate their building height compatibility with kind of a height diagram that shows how they're accomplishing that step back method for the extra separation between the tent and the property boundary. Also, they're providing the 20-foot setback buffer on the east and west property boundaries. They are asking for specific approvals, as the applicant alluded to. And it's only for the seasonal grass parking area that's kind of in the center and the north portion of the property. This map that you're looking at right here doesn't go all the way up to 51st Street, so it's not showing you the north side of that Bulls Creek because there's nothing going on there. There's nothing being proposed in that area. So the specific approval requests are to waive the requirements for providing enhanced landscaping for VUAs exceeding 1,000 square feet. It's also asking to waive the requirement to provide a landscape island every 10 consecutive parking spaces. And then the third specific approval comes out of LDC section 1005.11 for construction and maintenance. They've asked to waive the requirement to delineate the seasonal temporary grass parking spaces with wheel stops and paint markings, et cetera. And staff is in support of these specific approval requests. I also should mention about the permissibility of the property or the proposed use. So when we look at the comprehensive plan and we investigate what Res 9 will support in their range of potential uses, this use does not come under what most might think circuses would fall under. If you actually look at our definitions, you have to have an animal to qualify as a circus under our definition. And based on the information the applicant supplied to us on the front end of the application, we determined that this more coincides with our definition of medium-intensity recreational uses, which is to say that it functions more like a performing art. It functions more like a theater, and in the absence of animals, then we're inclined to hold this use to the definition of medium-intensity recreational, which is within the potential range of uses for the Res 9. And it's also a permitted use in the permitted use chart under the PDMU zoning district. So we have permissibility all across the board for the use. So the comp plan says it's supported. Now the comp plan asks us to go to the LDC and see how we can implement this use and mitigate any measures of incompatibility. And one that was pointed out is the minimum requirement of a 10-foot buffer. They provided 20. The other implementation mechanism for any incompatibilities that might be present with this project is the fact that we have 401.5 that regulates building height compatibility, which is to say that when you exceed 3 stories, you have to provide additional separation, and that's been met and provided here with the 50-foot setback. The ROR is another future land use designation that obviously would support the mix of uses in the 2-story building. They're well below their minimum or maximum FAR requirements. They're also well below any density requirements of the ROR. And to go even further, today as this property stands, it has entitlements for development, not to be confused with any site constraints that might come up with engineering, floodplains, or the like, but just from 20,000 feet in the air, they have permissibility in the Res 6 and the ROR. Today they could come in here and do apartments. Today they could come in here and at least along the road frontage in the ROR, they could do a slew of commercial opportunities there as well. And one of the things that really helped us get through the project is when the applicant committed to the 40-day limitation on the duration of the events. I mean, if you do the math, 40 days out of the 365-day year is just over 10% of the year they're asking for the use. So that plays a big part in that implementation mechanisms that make available to us through plan developments, because we're able to mitigate other measures such as the duration of the event with stipulations in the plan. So that's what we have here with the project. FDOT controls the access. That'll be looked at the time of final site plan. They'll also have to come in for temporary use permits for each time they want to conduct one of the 20-day events. On that temporary use permit, we have the opportunity to go more in depth about the parking, maybe the overnight stay, and some of the particulars that might, further mine down the details of what's put in the staff report for the entitlements of the zoning. I'd be happy to answer any questions if you have any. Oh, I'm sorry. And also handed out to everybody was some last-minute public comment, I think, that came through the wire between in the last couple of days.
Thank you. Thank you. Any questions for Mr. Robinson? Very good. I do have a question for Mr. Gerstenberger, if you could, please.
Morning.
Good morning.
Good morning, Mr. Chair, fellow commissioners. Thomas Gerstenberger, Public Works Department. I have been sworn.
With regard to Bowleys, the adopted FEMA maps, is there a current process in place with FEMA and the county to modify the floodplains, since they seem to be very different from the published maps?
Mr. Chair, yes. Let me start off with the existing firm maps. So the existing flood insurance rate maps for this particular area are derived from as far back as the 1992 effective firm. So as far as what the firm shows today, what the county regulates today, as far as for the floodplain ordinance, as far as for establishment of a base flood elevation, as far as development within the lighter pink area that's shown on this particular map, which is located in the floodway, would have to comply with the floodplain ordinance and FEMA regulations for development within those particular delineated areas. Now, that being said, and as Mr. Credit already alluded to, the intent is for this development to be at grade, for there to be no utilization of fill to elevate above existing grade with respect to the proposed recreational uses. Now, as far as the area up front, the area up closer to State Road 70, and this particular area is pretty much outside the 100-year floodplain as shown on this firm map. Now, if I go to what most recently was approved through the Southwest Florida Water Management District Governing Board, looks very much different. This is from the Bowleys Creek Watershed Management Plan, and as I just said, this was just recently approved by the Southwest Florida Water Management District back in November of last year. Was a joint watershed management plan between the county and SWIFMUD. This 100-year floodplain delineation, it has much more detail as far as drainage modeling. What you'll also see on this map is there's much more information as far as stages along Bowleys Creek. The intent, county staff intent, is for this 100-year floodplain delineation associated with the water management plan to be incorporated through a map amendment into the flood insurance rate maps.
Very good. And is Bowleys a maintained conveyance?
This, Mr. Chair, yes, that is correct. This particular area, and I'll use the Bowleys map again. This particular area of Bowleys Creek, yes, it is county maintained.
Okay, all right. Thank you. Any additional questions for Mr. Gerstenberger? Okay, thank you.
Thank you.
Thank you. All right. With that, we're going to go ahead and go to public comment. I've got a couple speaker cards here. We'll go ahead and go through these. And I'll call your name, and if you would come forward, state your name and that you have been sworn, and you'll have 3 minutes unless you're speaking for a group. I think I have a request for additional time. If you have authorization to speak for a group, it'll be 10 minutes. So first speaker card I have is Jose Padillo. If you would, come forward, state your name, and that you have been sworn. Thank you.
Hi there, my name is Jose Piliado and I've been sworn.
Thank you.
Thank you for taking the time to listen to me. I live right next to the property that's been presented. The Little Finger, 16th Street East. I think it was mentioned at one point that it was at one point part of the drawing plan. Don't have the document with me, but in one of the drawings that was presented, a Heislines property line and our road was on their drawing. The last one of the newer drawings is just showing the outline, but it's not detailing anything on 16th Street East. My concern is a few different things because on one of the drawings they had traffic coming in through 51st. It had some handwritten. Don't have the document unfortunately with me. I left it at the house, but it's good to know that they have planned to come through 70. So, but my concern is, why did they have our road on their property line at one point, and now they're saying that that's not that's not what they have in mind now? How does that work? Are they allowed to design and keep our entrance, because that's the only entrance to our properties there? And my concern is that, I mean, me personally, I don't want any traffic. They're not showing the parking lot. Also, I'll be facing the parking lot when that's, whether it's grass or just talking about the front of the project. But towards the back, that's where my house is, and that's where all the other houses are. And it's very peaceful and quiet now, but now talking about traffic and noise and alcohol, and I'm going to be steps away from their parking lot. Not to mention if it's going to be lit up. How many times a day the shows, how many cars. So it's that's my concern, and I would like to keep it the way it is. I mean, if it can stay, birds, owls. Oh, not to mention vegetation. Right now it's halfway cleared. The property had more vegetation before. Now it's or that for the parking use. What's going to happen to the rest of the vegetation? So there's a few things that I'm concerned for. For moving on with the plan. Yeah. Any questions for me?
Very good, thank you. And just to clarify or explain the process, usually from the public, we get comments, we're making notes.
Okay.
There may be questions or comments that are more appropriate for staff to answer, and then there are others where the applicant has the burden to provide a response. So we'll make notes and follow up with those things that are.
If they can explain a little better, I'm sorry.
Yeah.
On 16th,
Yeah.
16th, how at one point it was
Yep.
on there, and now so that was one.
Yep.
Even they said that's the issue we're having. Yeah, that's the entrance to the houses.
Got it. Thank you very much.
Thank you, sir.
Very good. The next speaker card I have is Margie Nanny. And Margie, I think you asked for additional time.
I did, thank you.
So
And forgive me
10
while I
minutes.
try to figure out how to navigate this little clicker right here.
No worries.
And also, the eye contact may not be great, because I do have to read this, so,
Alrighty.
okay, whenever you're ready.
Very good. Go
My
ahead.
name is Margie Nanny, and I have been sworn. Mr. Chairman, members of the Planning Commission, and staff, it is an honor to come before you to speak on behalf of a group of concerned citizens who, like so many hardworking members of our Onico neighborhood, couldn't attend. We're opposed to Circa Italia's proposed rezoning of a tiny 5.6-acre parcel from professional office residential to planned development mixed use to operate a potentially R-rated horror-themed circus for adults only. We understand that the applicant, their attorneys, and county staff have run this plan up and down the present and future land code book for compatibility before bringing it to you. On its face, the rezoning application may check all of the approval boxes, but clearly, this is a very different request than you regularly consider. For this reason, we ask that you put on a different set of glasses and look at it with an open mind. Please read between the lines about the implications of approving and see what it means for the character and future of our neighborhood between 15th Street East and US 301, and vote no on this application. We feel it's important to provide a backdrop regarding this historic part of Manatee County. It's rapidly disappearing. We hope to clearly put our passion in context about the importance of preserving what is left of our neighborhood's unique qualities, integrity, and long history of working hard to educate and build family character. This project is in the heart of Old Onico, one of the highest points in Manatee County, which is why the old Minnesota Cemetery was placed, quote, up there on the hill. Onico was nicknamed to represent one company, since the Reasoner family's Royal Palm Nurseries used to be the only large company in the area. A car wash is going up there now. They were internationally known for producing exotic hibiscus flowers and other plant material and supplies such locations as the Edison Ford homes in Fort Myers. The area was known as Manatee County's garden spot. Onico also had many citrus groves. They're all gone now. Thompson Groves produced the first pink grapefruit here in 1913, and Reasoners propagated it to the world. Beginning in the late 1800s, neighborhood students were educated at Onico Elementary, one of our county's oldest public schools, which remains today as a neighborhood educational anchor. The section between 15th Street East and US 301 is Old Onico, our neighborhood. We are a very diverse community anchored by many churches of all denominations who operate youth programs plus public and private schools. We have a post office, daycare, many professional office buildings, including a veterinarian, medical offices, and an engineering firm. Onico is home to one of the only privately owned residences built in 1908 that's listed on the National Register of Historic Places. On either side of the busy six-lane highway are quaint, tree-lined, quiet streets and residences, which are buffered by the sound of the road, many which directly abut the proposed circus site. They will be highly impacted by this project. This aerial graphic puts this all in context so that you can see the geographical logistics of a proposed circus in our neighborhood relative to our churches, schools, and historic sites. Our family has lived on State Road 70 since 1985 and has deep roots. My great-great-grandfather, James Harrison, was the area's first surgeon. My husband, Pat, is a Manatee County native, and we both just retired from years of service to the school district of Manatee County. Our two sons were raised here and attended Onico Elementary. Both of our sons and my husband are all Eagle Scouts, and all four of us served Scouting's Troop 10 for 17 years at nearby Onico United Methodist, who has hosted Scouting for many years. In the 1980s, we worked with the FDOT, churches, and school when State Road 70 was widened from 2 to 6 lanes. Together, we garnered support to push the alignment south, which resulted in keeping the highway out of the school's playground while preserving the church's building and saving a historic oak tree. The net result was a win-win, with the school district moving ahead to rebuild a new, safer Onico Elementary. When FDOT was going to remove the school's slowdown zones, we lobbied to keep them, and we also saw that school sidewalks were built. We have dug deep to preserve Onico's history, but sadly, we've also noticed its character disappearing, with an uptick in crime and homeless camps, which is very troublesome. With this as a backdrop, we hope you see the value in helping us preserve it and enhance it, not deplete it. The negative implications about this rezone are many, and traffic is at the top of the list. FDOT estimates about 36,500 cars traverse this section each day. The speed limit is 40 miles per hour, but vehicles regularly exceed it. Crashes are common, and the frequency of EMS and fire safety equipment rushing to get to accidents light up the days and nights with sirens, and peak hour traffic noise is deafening. The circus will add increased noise, bright lighting, and can decrease property values. Who wants to live next to a circus? Circa Italia's plans are to shoehorn an arena and a few outbuildings into a small parcel wrapped around an FDOT retention pond along State Road 70. On the north side of the site is a heavily treed site that abuts a private road with homes, as the gentleman just said, and runs along Bowley's Creek, which is a protected wetland and assists drainage for this area. The project is located just 750 feet from the congested intersection of 15th Street East, just a few hundred feet from the railroad tracks. Trains with no regular schedules back up traffic in both directions all the time. Heavy intersection traffic makes it difficult to turn onto State Road 70 off side roads. During my recent conversations with FDOT staff overseeing the project, it seems Circa Italia's plans are still being reviewed and access seems problematic. Putting a circus arena in and running 40 shows per year with 400 people at each event is really not a good fit at this site. We understand that at this time that I looked, they had only put one access on and off this property, which poses safety implications in case of an emergency. The traffic going in and out after shows can only turn right or west. Cars heading south on 15th Street East and those wanting to head east on State Road 70 will have to cross over 3 lanes of traffic to get into the 4th turn lane. Those who want to go east will have to make a U-turn at the 15th Street light against opposing cars turning right to head east off 15th Street East. This will add to the already frequent crashes and pedestrian actions at this location. 15th Street East is already a nightmare, a major artery that has been neglected for years. 2 north-south lanes back up traffic for blocks at State Road 70. Heading north into Samoset, it's a treacherous road with deep, unbarricaded, water-filled ditches on either side. Before any consideration is given to adding more hazards to this artery, authorities should first address improving and widening this road. The most troubling concern of all is the theme of the circus shows. The applicant operates the R-rated paranormal circus and held performances in Palmetto last January. Nobody's talking about this, but we are. Children under 13 are not welcome to this adult-themed show. 14 to 17-year-olds must be accompanied by an adult. Media reports state the show has adult language, sexual jokes, racy costumes, and lots of blood, gore, and general creepiness. Even one of their performers stated, "It's not for kids." Though Circa Italia internationally has 4 themes, the applicant's representatives would neither confirm nor deny that the adult-only paranormal show will be presented in our community. To us, this is the equivalent of putting an X-rated movie theater in our backyards. How does an adult-only leave-the-kids-at-home show fit in with our neighborhood? While I'm sure the performers are talented, some media reviews state this is a horror-themed evil show. This is the last thing we need as we work hard to lift our youth away from such darkness in a world that needs more hope and positive character development. Manatee County Planning has positioned this as theater. Does an R-rated paranormal circus fit that criteria? We think that's a stretch. If we open this door, what's next in Onico? This project appears to purposely been a well-kept secret flying under the radar. The applicant, using the 500-foot radius county rule, only had to notify about 145 residents. Imagine that, having a potentially R-rated circus just blocks from your home, school, or church, and you never knew about it. Instead of holding a community meeting, the applicant chose to invite 145 homes to attend a 30-minute virtual Zoom meeting and only a few attended. Our group felt it was so important to let the community know. We paid for 1,400 mailers to mail to the neighborhood to let them know. I'm wrapping.
Thank you.
More trouble regarding the lack of comparison was that until last Monday, I saw no yellow sign posted on the front. All of this, and there was a little one on the back, all it's created a lack of trust. We plead for you to vote no to this rezoning. A yes vote will open up an unknown future for our community. We are very proud of Oneko's history. We don't want to wipe it away. The current professional office zoning is appropriate, should not be changed. More businesses and affordable homes are a better fit than an R-rated circus. Oh, did you cut me off?
No, but,
I'm done.
Yeah,
Okay,
thank
we
you.
hope our story resonates with you, and we do thank you so much for
Thank you.
considering it. Okay, I'm sorry I exceeded the
no,
time.
no worries. Thank you. All right. The next speaker card I have is Michael Regard. Riegert. Good morning. If you could, just state your name and that you have been sworn.
My name is Michael Rieger, and I've been sworn.
Thank you.
I agree with everything that Margie said, and I want to elaborate on what Jose is saying. The 16th Street East is an easement, and that's the only way to get into our houses, mine and Jose's, and there's a few other houses over that way. I have a property survey for me. I don't know where you want me to put it.
If you want to enter it into the record, if you could after, just hand it to the clerk and it'll be
All right,
part of the
I have my
package.
property and his thing that they sent me, it seems like he's running straight down 16th Street East, and I own the easement across 16th Street East and the property east of that going towards Bowlees Creek. I have another 15 feet across that. And it just seems that they just blew their big dark line straight down 16th Street East, saying that that's theirs, and it's running through my front yard. I'd like to know what the story is with that.
Okay. All right.
Okay, and the other problem is, of course, the traffic. Just to get up to 53rd from 51st Street to go that way, right now it's a nightmare. And I can imagine that. And they're saying that they're not doing anything down to 51st Avenue East. But when we first got all this information, that's where they said all the entrances were and everything. So now we want to know what's going on, and are they going to snow you guys and then put this in later on? You know, this is, and my main thing is it's a personal thing. You know, they're running through our front yard, and that I got to find out what's going on.
Very good.
Okay, I'm stuck. I want to do improvements to the house. I can't do anything. They sent me this 2 months ago, and I'm looking at this thing, and what's this, you know?
Very good. Thank
Okay.
you. And just for information, these plans change through process. So the one that comes in front of the Planning Commission, which we are a board who makes recommendation, is unless there's modification, which would be unusual, it's the one that's going to end up in
Let me
front of
just
the
ask you
board.
this. Normally, you don't take anybody's property, am I right?
That property rights are very, very
Thank you.
important. so,
That's a good thing for me.
But if you provide that information to the clerk will make sure that it's part of the record that goes to the board, and I'm sure there'll be some discussion after we take public comment on this matter. Thank you. I don't think there's a name tag. Oh, there is a turn. All right, I'm sorry. I have one more speaker card. Brandon Bassett, if you could, please come forward, state your name, and that you have been sworn. You have 3 minutes. Good morning.
Brandon Bassett, good morning. I've been sworn.
Thank you.
So my wife and I bought our house on 17th Street Court East, which is the street just east of this property, back in 2009. We really enjoy the neighborhood, the area, and we have no plans to move or go anywhere. Give you perspective, if I go out my front door, the tent will be almost directly across from our house. But we're pretty neutral about the whole thing right now. I see positives and negatives to it all. We've been to several of this company's shows, and we've enjoyed them all. They've been fun and family-friendly. I think they might have indicated they'd be willing to not have the paranormal show there. that might be a way around that, I'm not sure, but I kind of like the idea of having that property empty, kind of like Jose had said before. So if the option is between potentially having an apartment complex go in, or somebody stuffing 15 or 20 small houses in there, I'd rather have the circus and have that place empty 90% of the year. So that's one perspective on it. I'm not going to be impacted as much as people whose houses actually back up to it, so I certainly understand that. Traffic noise is always a concern. But I would say one street the other direction, there's a big church that probably has as many or more parking spaces and sometimes plays loud music, and it never really seemed to be a problem. So my biggest issue with parking would be if people start parking on our street, because it's a small street, there's no sidewalks, and I could see people kind of pulling up into yards a little bit as well. So if there could be some, guarantee or mitigation on that would be certainly helpful. Otherwise, if they go in, we're not going to be mad about it. If they don't go in, we're not going to be mad about it, but just want to kind of give you our thoughts on the whole thing there. So I think that's it.
Very good, thank you.
Thank you.
So those were the speaker cards I have, but still, if anybody wishes to come forward, please do. You have to come up. And if you would, state your name and that you have been sworn.
My name's Stella Burnett, and I have been sworn.
Thank you.
I got one of the postcards. My daughter doesn't drive. We have many kids that walk up and down the sidewalks. We have many kids that go to the Amico school, they walk. I'm just very concerned about all this. I'm concerned about the circus. You say tent. I hear music through my house. I know that those tents, how do they contain the music? I'm just totally against it. I agree with Margie, and it's sad. They've asked for, at least I heard, 3 waivers. Why are we giving them waivers? Aren't those things set in place for a reason? I totally disagree with giving them any waivers. Thanks.
Thank you. Again, if there's anybody else who wishes to come forward and make a comment, please do. Again, state your name and that you have been sworn.
Hi, my name is Wen Chan Tong. I have been sworn. I didn't plan to speak today. I'm just sitting here taking notes, and I have many questions here after I hear this. So I just wanted to share with my question to the board. Maybe I can read the question for you guys.
Thank you.
So first thing I see from the presentation they have is a picture from the south side, which has the car garage right now, or whatever, the shops right now. And they show the nice yards, the grass right now. But the picture they didn't see show it's a lot of trees. Like, thanks for this lady. She showed all the pictures so that people can have the better idea about the whole impact for the site. So my question first is regarding the grass parking area. So we cut the trees and we put the grass, and you guys talking about you guys have no plan to fill the grading, right? But do you have any plan to cut the grading? And will any grading or elevation will be changed? Any drainage plan going to be put? It's by the environmental wetland. So what's the buffer besides, you mentioned about 10 feet or 20 feet buffer from the residential area, but how about the buffer from the environmental wetland? Second question, 40 days a year, which specific days? I believe there is no defined schedule per the future years. And also 20-day setup. Those setup days, how the traffic and how the construction gonna look like. Yes, there is the elementary school just down by the street. How the schedule gonna be looking like to impact the elementary school? I didn't hear anything. I think some of you asked the question and they said they don't have the schedule for now. So other than 40 days, what's gonna be look like for those commercial buildings? I didn't hear about that. And I hear about this is a recreational use. It will be similar as any other commercial area use, but I totally different ideas, not agree with that, because how that recreational circuit is going to be similar as commercial areas such as Walgreens, Burger King, and church, or any other apartment. It's not apple-to-apple comparison. So how you can use apartment to compare with circus creationals. Hold on, I have a lot of notes. So for the grass parking area, back to that questions, how the lighting look like. I didn't hear any plan. No overnight parking, but I still hear that maybe that overnight permit's gonna be needed. So that's conflict from what I hear that no overnight parking. Even for no overnight parking, but how late the parking gonna be, how the site prep gonna be, and also where is the construction access, how the construction gonna be look like, how the demolition gonna be look like, and how the construction schedule could be look like. And traffic control, how the traffic control plan gonna be, has any noise and lighting study has been performed. I hear some question asked for that, but I heard that, they are waiting for the more study to be performed. So with all those pending questions or unknowing questions, I'm just asking the board to not making decision at this moment, at least, because with all those open questions, how you can be convinced that you guys can approve something with all those pending items. Thank you.
Thank you. All right. Again, if you could state your name and that you have been sworn.
My name is Terry Hale. I have not been sworn because I didn't understand, so.
Okay. So again, if there's if there's anybody else who wishes to speak on any quasi judicial matter.
I apologize for that.
You're not alone.
Yeah. Have some frequent flyers that are being sworn in, so.
Do you swear or affirm that the factual statements and factual representations which you're about to present to the Planning Commission will be truthful and accurate?
I do.
Thank you.
My name is Terry Hale. and I have been sworn.
Thank you.
I represent Community Christian School and Community Baptist Church. I appreciate, first of all, I do want to say thank you to you as the board for your willingness to hear and for the work that you do. We are appreciative of that. And it can't be easy at times. Obviously, there is a difference of opinion here, but we do thank you for that. As a long-term resident of Bradenton, I've lived here 18 years. I've worked at Community Christian School for 26 years. And our community, and I appreciate what Mrs. Nanny said, she very well encapsulated what I believe to be true. Our area, Oneiko, has traditional values. It's a family-oriented residential area. It has been that ever since we've been part of that. There are at least 3 schools. I represent one of them. And there are several churches, and I represent one of those as well. We're concerned about an R-rated venue and the impact that would have upon the children. I would say our school probably and church represent about 1,000 people or so. And we're concerned about that and the adult themes and the paranormal activity that's associated with this particular event. So as a representative of these entities, Community Christian School, Community Baptist Church, we would ask you respectfully to decline the requests. Thank you.
Thank you. Again, is there anybody else who wishes to come forward and make a comment or statement regarding this application? Anyone at all? Okay, seeing no one else come forward, we're going to close the public comment portion of the hearing, and I have a couple questions that might best be answered by the applicant. And I don't know if it would be the engineer or transportation engineer that could answer this, related to access, I think it's 16th Street Court. What is the understanding with regard to the easement that is adjacent? Has there been any discussion related to having two driveways within potentially feet of each other?
I'll start, and then if Mr. Crott wants to jump in, he can.
Very good.
So there's an existing, I think it's about an 8-foot access easement that runs through that area. It's a dirt drive. That is not going to change. That easement is already there, and that won't change without the approval of the easement holders. Now, there has been some discussion about whether or not it makes sense to try to consolidate those access points, especially from DOT's standpoint, whether it makes sense to do that. So we have been looking at some of the options there for access, and one of the versions of the plan did show essentially utilizing the newly constructed paved access to then branch off and provide access to those residential units back there that utilize 16th Street East. So nothing along those lines is going to happen without their approval.
There being the neighbors?
Correct, the property owners that have the easement rights. So that would continue to remain in place unless they agreed otherwise.
So in short, it's unknown? It hasn't been decided?
That's right. I mean, at this point, we think it could end up being two access points there, with the dirt drive continuing and then the proposed access next to it.
Yeah. And we can't have comments from the audience. And has there been any coordination with regard to providing if it is an access, if there's a willingness for them to release those rights?
No, we haven't had any of those discussions yet. Because, I mean, at this point, we still need to work through the DOT process as well to see what it is that they're going to allow or what they want us to do. So, and we also have potential issues on the county side because they look at the access and whether it's going to be for commercial or residential.
Right.
So that's just something we'll have to work through as we get towards final site plan.
Okay. Have those discussions, well, you just said the expectation is with regard to final site plan.
Right. I mean, what we're showing now is essentially two accesses there.
Yeah. When you say two accesses, you're talking
I
about
apologize.
the existing
The existing
and
16th Street private access, and then the
adjacent
proposed access for the commercial.
Okay. All right. Thank you. And just for clarification, the easement resides wholly on the neighbor's property and the property boundary. There's no overlap of the easement or the drive within the applicant's property. Is that correct?
Correct. The easement is not on the easement is not part of the project application. I believe our client has actually acquired that piece of property that the easement runs across, but doesn't affect the access rights of the easement holders.
So okay, all right. I don't have property lines pulled up, so I didn't.
Right. It is not on the project site.
So you're not taking their property?
Correct.
Yeah, okay.
Yeah. But property ownership and rights can be separated, so we need to make sure the rights are protected without the property, even if the property is transacted. So, all right, thank you. One of the other questions that I would have, just for clarification, there seemed to be some confusion related to access from 51st, is it, to the north?
North side.
That might have been, was that maybe a concept that was floated originally and then has been since eliminated or removed from the
I don't remember us having a concept that showed access from the north, but regardless, there's nothing proposed there now. There's no proposed access, there's no proposed connection across the creek, and nothing proposed from a development standpoint north of the creek.
Is the applicant own property that is adjacent to 51st?
The project site does extend all the way to 51st.
Okay. Okay. Some of the graphics, they made a very clear distinction that it kind of narrowed. I couldn't tell if it actually
It does, it narrows. I mean, it is, obviously the creek runs through there. It's a heavily treed area. It just doesn't make any sense to try and put an access through there.
Okay. One of the other discussion, the themes that came up frequently was the types of performances. Have there been any discussions, I guess, themes, I think is what the way it was described? Yeah. Is that typical that the themes for the the performances are different?
They have several, well, first of all, let me say, I think it goes without saying that we don't base land use decisions on the content of a performance. They have several different shows, just like the movie theater that's at the corner of State Road 70 and 301. There are shows for adults and there are shows for kids. I mean, so it could be, any mixture of those.
Yeah, and I'm going to turn this into a land use question. So the different performances, the themes, is it the same structure for each one? There was an example that was shown that had features that seemed to stick well above the top of the structure.
Right, so we would be limited to what has been presented here, meaning if there are different shows with different tents, we're going to be limited to that, to the maximums that are presented in the plan.
Okay. And just a couple other simple questions. Did you have discussions with staff? Well, let me maybe kind of set the question up. The applicant's name has circus in it. And I think even the way it's advertised as a circus. If this were a circus, would the location be appropriate, or would it be exempt by the county rules and regulations?
I will say that we had I believe a circus is also in the medium recreation category, but it has some specific use criteria that would apply in this case if it were a circus, but the definition is clear that it is intended for lions and tigers and bears because there are criteria related to that. So it was clear that this use did not fit into that category.
Right. I think that's a dated definition. It seems, you don't see that anymore, so I.
Thank God.
Yeah. But I'll follow up with staff regarding that matter. Any other questions?
I got a quick question.
Mr. Ron.
There seems to be some concern about the operation or when it's operating. Can you state again that this is only going to operate for 40 days a year? That's it. There won't be anything before that. The tents or whatever go up, the performance is for 40 days, and then it's gone.
Well, yes, but let me clarify. It's not 40 days of performance. The 40 days includes the setup and the rehearsal and the takedown. So that's why I was saying up front, you get a 20-day permit, you're only going to have a couple weekends of actual shows with patrons. The rest of that time is your setup, rehearsal, and then the takedown afterwards. So that's why I said it's only going to be a handful of actual days with patrons per year.
Does the current operation they have, are they still operating at Riviera Dunes? Does that operation go longer than 40 days or?
No, my understanding is it's the same type of process, temporary use, and they're there for 2 or 3 weeks.
Okay, thank you.
Any other questions for the applicant, follow-up? I have one additional question. This seems to be a very heavily treed site. Was there an investigation related to the impact of doing development with regard to the canopy, the current canopy that exists? How's the applicant going to mitigate that?
Well, one of the benefits of the grass parking area is you have the potential to try to save some trees. I think the applicant would like to do that to the extent they can. Obviously, you're going to have, when you look at the aerial, that whole area that runs along the creek that is heavily treed, none of that, there's a 30-foot buffer from the creek. So that area will all remain. It will be, remain heavily treed. We're also adding trees. There's a 20-foot buffer proposed along both property lines.
So I think one of the questions or comments that came up was related to Boley's and protecting it. So there's a vegetated buffer that would be 30 feet running parallel to Boley's Creek on each side, or at least on the side you control.
Well, that's a wetland buffer. Do we remove invasives in the wetland buffer? And it's what's that? Right, but it's still a 30-foot buffer that's proposed. So.
Okay. I guess the question is that if it's treed and the trees are not invasive, they'll be maintained.
Correct.
Okay. All right. Thank you. All right. Any other questions for staff? Okay. Thank you. I'd like to open it up for questions to the. Questions for the applicant. I'd like to open it up for questions for staff just to get some clarification. I had asked the applicant if this were actually a circus.
So we looked at that as well, Chairman Connolly. We've got definitions in the code. We do have a definition for circus or circus exhibitions. The main point of that definition is exotic animals. It seems to focus more on exotic animals for that definition. So when we look to the recreational uses, there are 3 varieties, high, medium, and low. The high variety of recreational uses also includes animals. They did not propose any animals, so we went to the medium recreational, which has permissibility in the definition.
Okay. So if does the recreation definition, does it allow if somebody set up a stage and had a concert that was just on the ground?
Let's see here. Well, it does say theaters. It doesn't say outdoor theaters. I guess theater could.
Well, the way it's being presented is it's low impact to the area, so I might have extrapolated some of the.
Well, it could be extrapolated. Let me just read the definition. Medium intensity recreation shall mean any recreational facility such as billiard or pool halls, bowling alleys, banquet venues, or dancing establishments, skating rinks, shooting arcades, indoor firing ranges, miniature golf courses, theaters, and similar facilities.
Okay. All right. Seems pretty broad.
Yeah.
All right. Any other questions for staff? Yep. Okay. Thank you. I guess we've had testimony and got a couple questions answered. I'd like to go ahead and allow staff to provide any closing comments, statements, or clarifications.
Well, I would say that staff made no comparisons in the uses between multifamily apartments and recreational uses. The statement that was made is that both of those uses, apartments and recreation, have permissibility here. And the point that was made is that, the apartments could be developed permanently year-round versus the recreational use that's being proposed for just over 10% of the year. That was the comment made. There was no comparison there.
Okay, thank you. All right, with that, we'll go to applicant closing comments, rebuttal.
Thank you, Mr. Chairman. I will be brief because I think that we covered a lot of the resident comments during the board questioning. I did want to follow up on Marshall's comments because I think it's an important note. You know, when you look at this site and how it is planned by the county, you know, it's got an ROR designation, it's got a Res 9 designation. Those are, I mean, the ROR is a really intense future land use category. That Res 9 is a relatively dense future land use category as well. It's also in an activity node. And so when you look at those on a mixed use project, this project could ask for up to 20 units an acre on the residential piece. I mean, that's the kind of density and intensity that the comp plan would allow in this area. When we look at the site, we think that coming in with a temporary recreational use here with limitations on it is a better approach. This is a known quantity. They've been operating without issue within the Riviera Dunes community for several years. And I did also want to touch, there was a comment about traffic control. The applicant always has law enforcement to conduct traffic control. That's typically something that comes about during the temporary use permitting process. We had actually proffered that as a stipulation, which I think there were some concerns about enforceability, but just so everyone is aware, that is something that the applicant will have. There will be law enforcement conducted, similar to, you know, you'll see at some churches where they have law enforcement there when they're letting out and whatnot. So that is something that will be done. And with that, we'll conclude, and happy to answer any additional questions.
No more questions, though. All right, thank you. All right, we're going to close the public testimony and open it up for discussion, deliberation, thoughts, enter a motion. What's the pleasure of the commission?
My thought is, I just don't know how they can control the volume of sound. I know there's very limited shows, but I have friends that live in Riviera Dunes and been in their place when they were even practicing, and it's loud through a $1 million condo.
Yeah.
So I just cannot recommend the circus part of it.
I agree, and the 40 days doesn't really convince me. I mean, if it's a nuisance or there are issues 40 days of the year, then there's a problem. I think there's too many negative impacts potentially, and I don't see how they can be adequately mitigated. I'm not convinced that they could.
You know what, and I hear that, and then I look at the map, and what's happening all over Manatee County, which is, you know, there is this urban densification, and this is where densification should occur. Now, whether you want, you know, all those filled with apartments and people going in and out of there versus something that's got green belt and protects the water that's there, that value to me is significant. And I do think it's a challenge. I'm not going to get into the conduct of whether it's, you know, adult or not, because my television gets a lot of stuff I don't watch, you know, so but I do see some value in kind of a unique condition there that's tied into a commercial node. And I like the green space. I mean, I love that by that buffer area, they figured out a way to just keep it mitigated. So I see both sides of it. And if they don't do it, somebody's going to come back and say, okay, I want to stack it up with apartments. And I think we got a lot of apartments. This is unique, and so I think I'm going to be in favor of it.
So, very similar, Mr.
Sorry.
You're going to make a motion?
No, I did have one comment. So with respect to the noise, just remember that, you know, there is a county noise ordinance, and, you know, that's equally enforceable to an entity like this proposed performance theater activity.
Yeah. Okay. Yes, Mr. Ralph.
I don't know if this is going to work. Okay. Red button.
You're live.
Good. Okay, I'm live. Frankly, my children have gone to see this. And this is probably no worse a horror show or a sex show than you would see on your computer or on your television or whatever. This is not the only venue that they have. As I was riding to see a famous opera star north on Route 4 in Orlando, there was a set of their tents there as well. This is a very popular operation. It's clean, it's neat, it's going to provide some entertainment for the area, and again, it will be entertainment as against another set of apartments, or another high-rise, or something else. And it will handle the environment well in addition. I have a problem with a little bit of parking, but I know, and I've seen the county and the police department handle the parking on Route 70 when they want to, with the correct number of bodies, and make it work. So I'd be in favor of it.
Very good. Mr. Smock, are you
Trying to make sure I'm live.
Yeah.
You know, it's a true challenge in all this. Oniko is a distinct and a beautiful area, and you know, Mrs. Nanny really pointed out a lot of truths in that matter. But the reality is that when this property is clear, it's going to be a safer area than what it is now, because you're not going to have homeless camps and you're not going to have what's there existing. You know, 40 days isn't that bad for the potential noise that could come from year rounds of apartments. You know, you're not going to have the crime issues attributed to low-income housing that might bring in with an apartment complex that would potentially come within that district. You know, traffic would be limited to 2 weeks semi-annually. That would be a major issue. Yes, the noise is going to will be an issue. Content, I'm nobody's judge, so I'm not there to be able to have to say what's good or bad content. That's not my place. So I would actually be supportive of this, because I think in the long run it would actually be better for the community than a lot of things that could go there.
Very good. All right. Mr. Ron, you have an opinion?
I'm not going to. I don't need to keep repeating what that resolution says.
Come on, let's do it. No. All right. With that, Chair will consider a motion. Somebody.
I'll make a motion to accept the submission as presented with the conditions that are stipulated.
Very good. We have a motion. Is that sufficient? Second. Mr. Ross, second.
And just to clarify, that would be as proposed in the staff report, the motion for approval as proposed in the staff report?
Okay.
You still want to read it?
Very good. We have a motion for
Go ahead and
approval.
read. I'll just read it just to be complete.
Yeah.
All right. Based upon the staff report, evidence presented, comments made at public hearing, and the finding of the request to be consistent with the Manatee County Comprehensive Plan and the Manatee County Land Development Code as conditioned herein, I move to recommend adoption of Manatee County zoning ordinance number PDMU 2115 ZG, approval of a general development plan with stipulations A1 through A11, B1 through B7, C1 through C5, and D1. Adoption of findings for specific approval and granting specific approval for alternatives to the Land Development Code sections 7013A2. I'm not going to read the whole thing, but 7013A4 and 1005.11. I think that covers everything.
Very good. Such an attorney, so.
And so is my motion.
Yeah.
Yeah.
Okay, we have a motion and a second by Mr. Roth. Any additional discussion? I think we've kind of discussed it sufficiently, but just one more opportunity. Okay, seeing no one, the Chair will call the matter to vote. All those in favor say aye.
Aye.
Can we see a show of hands, please?
Aye.
1, 2. Is your hand up, Mr. Ron? Oh, you can't be like halfway. Okay.
He was
All
talking
right.
about you.
Opposed, like sign.
Aye.
Aye.
All right, chair votes opposed, so the motion passes 3-4. Whenever we have a discussion like this, I think it's important that we document or at least make a statement regarding the opposition. I think Mr. DeLesline, I think you had mentioned kind of your opposition.
Yes, sir.
And anything additional with regard to?
Just adverse impacts on adjacent residential.
Yeah, and I didn't make a comment prior to, but I'll just clarify. I have a concern related to compatibility between a venue and residential. That's the main thing that I see. That being said, if this were something, even if it were more intense, I think it might be appropriate if it were related to residential. So, but the use is kind of the thing. The ancillary use even is what I would have a concern about, and again, compatibility. So with that, motion passes 4-3, and that concludes that item. So we have 2 more applications. Those would be heard concurrent, correct? But we're also at the lunch hour. So I know staff is more constrained than those of us up here. What's the board? We can push through if do we need to take a break before, or?
These usually take a long time.
I don't
see.
I don't see them taking a long
You cleared the
time.
room, right?
Yeah. So, all right.
There's no public comment on either one of them.
Madam Clerk, do you need a break? Yeah. So, Mr. Neal?
Mr. Chairman, we think we might take 30 minutes.
Okay.
30 minutes.
All right, very good. So with that, we're going to go ahead and, I think, bulldoze through this, and I think I hear 30 minutes. I think we can beat that, so.
Okay, all right, challenge. All right, let me. Everyone just left. You can take a 5-minute break, and so I can get my team together. Is that all
Yes,
right?
please. We're going to go ahead and take a 5-minute break. Thank you. Pardon? All right, we're,
It's me.
yes, ma'am.
Did you want
Rosina. All right. I banged the gavel, but I didn't say we're going to go ahead and call the meeting to order. So, all right, we're on the board. Yep. So with that, let's go ahead and get back on the road. Sorry, a little behind here. So we have two applications. I believe the intent will be to open both of them together.
No,
No?
no. That's, I know I haven't been introduced yet, but at the direction of the county attorney, we were
Okay.
going to open the comp plan amendment and then give you an opportunity to vote on that. You can confirm that with
Okay.
council.
Ms. Schenk, are these to be opened individually?
Yes, sir. Do concept map amendment first, vote on that, and then do the next one.
Okay, all right, thank you. All right, that changes what I thought we were going to do, but
Sorry.
we'll roll with it.
15 minutes each one.
Ms. Lidar, can you
Yeah.
please read item 4 into the record?
PA 2203, Ordinance 2236, Village of Samazon, Small Scale Comprehensive Plan Amendment and Text Amendment. It's a legislative case and it's a privately initiated map and text amendment to Element 2, Future Land Use Element of the Manatee County Comprehensive Plan to change the future land use classification of 49.99 acres of a specific real property generally located on the west side of US 301, north of Moccasin Wallon Road and east of Fort Hammer Road at 11724 Moccasin Wallon Road Parish from US 3 Urban Fringe 3 dwelling units per acre future land use classification to the MU mixed use future land use classification and providing for a specific property development condition in the text of the comprehensive plan to limit the density and intensity maximum potential to a hospital containing a maximum of 150 beds and 125,000 square feet of medical offices. It's again a legislative case. Mr. Bill O'Shea is the case manager and Katie LeVar from the applicant is presented.
Very good, and this is legislative, so no ex parte and no need to be sworn, but Ms. LeVar, can you introduce the application? I mean, not introduce it, but yeah, introduce it, I'm sorry.
Sure, and thank you, Mr. Chair, Commissioners. As Rosina said, I'm Katie LeVar, planner with Stantec, working on behalf of Neal Land and Neighborhoods, and we're very excited to bring this small-scale comprehensive plan before you today. As Rosina stated, this is a privately initiated comprehensive plan map and text amendment for about 50 acres of land. We're amending the future land use category from Urban Fringe 3 to mixed use. The site is located on the west side of US 301, north of Moccasin Wallow Road, east of Fort Hamer Road in northern Manatee County. As many of you know, the Villages of Amazon South is an approved mixed-use development, which is zoned planned development mixed use, and has several approvals and amendments that have come before this commission over the past decade. Phases 1 and 3 are developed with residential lots. Neal Land and Neighborhoods is the master developer of North River Ranch, and they envision Phase 2 to be a compact, walkable village center that will serve North River Ranch residents as well as the broader community. Evolution of the development and the community needs has necessitated a change in future land use category that will support a broader range of uses that can be accommodated than what can be accommodated by UF3. And so as we evaluated the future land use map, we determined that a small-scale comp plan amendment to MU is appropriate to better support some of the more intensive uses that we're contemplating for this property, such as a hospital. During the review, we worked with staff to establish development limits to ensure that the proposed intensity is in keeping with the character of the area. And so we proposed policy 2.14.1.17, and I see that the text is quite small on your screen, but you should have it in your agenda packets. And the purpose of this provision is to memorialize development parameters consistent with the approved traffic impact analysis that accompanied the application. These limits are 150 beds and 125,000 square feet of medical office, with the ability to utilize a land use equivalency matrix if it's deemed necessary sometime in the future. That said, no additional density or intensity will be allowed to be derived from this parcel beyond the 150 beds and 125,000 square feet in the future. And so we've established what the thresholds for development potential will be with this commitment that we've placed in the comprehensive plan. I'd like to highlight just a few policies that are identified in the staff report that I believe underscore the appropriateness of this amendment. And I'll start with policy 2.1.1.3, which says designate on the future land use map land within currently undeveloped growth areas at densities and intensities that permit significant increases over current land use designations without creating urban sprawl. This plan amendment is located west of the future development area boundary. It's in an area that is served by existing infrastructure. And the addition of mixed use will allow for, again, a broader variety of land uses that will support the increased residential development that's in the area. And hospitals, again, as a use that is among the range of potential uses in this land use category. There are only two land use categories in the comprehensive plan that would support such a use. One is public, semi-public one, and the other is mixed use. But the future land use map from UF3 to MU is truly a logical transition, and I think this graphic really helps illustrate the fact that it's very, very small, but it's also very, very logical. Policy 2.1.1.4 says promote development in currently undeveloped areas that have the greatest level of public facilities available in investment. And so again, this project is part of a large master plan community, North River Ranch. It's being actively developed. There's significant access and availability to public facilities. As the maps indicate, we have direct access to US 301, and we are continuing to develop Fort Hamer Road, which now has a connection from this community south into Sarasota now. And so it's becoming an even more, Fort Hamer Road is becoming an even more significant roadway on the thoroughfare network. And then policy 2.1.4.5, permit the consideration of new residential and non-residential development in areas that are currently undeveloped, which are suitable for new residential or non-residential development. As I said initially in my opening comments, the site is partially developed with residential development. It's adjacent to other existing residential, and it's really suitable at this point for medical and hospital type facilities. And we think that that will serve the community very, very well. We're sensitive to the fact that mixed use is the most intensive land use category in the comprehensive plan. And so again, for that reason, we have worked very diligently with staff to bring forward an amendment that will allow the use of the category in a thoughtful and meaningful way. We are confident that encouraging a broader range of uses, like a hospital and medical office, will be a meaningful addition to the existing and future residents of Parrish in the North County area. We've reviewed the staff report, and we agree with staff's analysis, and we respectfully request your recommendation of approval of this comprehensive plan map and text amendment. Our team is available to answer any questions that you may have.
Very good. And I have one question, just a clarification. When you say hospital, you're referring to like an emergency, the typical full-service hospital, not a rehabilitation hospital or something a little less intensive?
No, it is hospital in the context that you're describing is, yes, it is among the range of potential uses that is permitted in mixed use, and that is one that we are highlighting, but there are a variety of uses that are permitted in that category. But yes, it would be a full-service hospital.
Okay, thank you. Thank you. Any additional questions? Okay, thank you. All right, we're going to go to staff presentation.
Good afternoon, Mr. Chair, Planning Commissioners. For the record, I'm Bill O'Shea with the Development Services. I have a PowerPoint that I'm going to go through. We'll glaze over the stuff that Katie covered. She did an excellent job of summarizing the request for you. So the site is located, as Katie said, north of Moccasin Wallow and west of US 301. The existing future land use is Urban Fringe 3. And the request is to go for approximately 50 acres from Urban Fringe, 3 dwelling units per acre, to mixed use. The applicant has also proffered a D5 provision to limit the entitlements for the mixed use portion of the development, as Katie had indicated earlier. And the proposed future land use, again, will be mixed use. Based on the history, it appears that the site in 1990 was under agricultural zoning, and the UF3 and PSP1 future land use designations. The current zoning is PDMU, or Planned Development Mixed Use. And I have a typo there, it's not mixed use medium. And UF3, PSP1, future land use categories. And again, the zoning is PDMU. Public facilities that will service the site include Harvey Elementary, Buffalo Creek Middle, and Parish Community High. There's no bus service available to this site. The bus service ends at Victory Road and 301. And there are multiple parks within a 5-mile radius of the site. Positive aspects of the application: mixed use is a logical transition between developments to the north, south, and west of this site, and is a continuation of the mixed use future land use category to the east. Some of the negative aspects include the maximum potential that this site could be developed at, which is significantly higher than the as-built environment and definitely more dense and intense than anything in the area. However, the future land use category change will ensure that development will be limited on this site to the 100, or the additional entitlements derived from the mixed use future land use category is limited to 150-bed hospital, and I believe it was 125,000 square feet of medical office. And at the time of future site plan submittals, staff will be conducting a detailed analysis of the capacity and impacts on public facilities, including utilities, transportation. Any further development of the site needs to comply with the Manatee County Land Development Code, including but not limited to building setbacks, open space, traffic design, roadway improvements, and stormwater requirements. Adequate buffering, landscaping, and design should provide a transition between the future development of the site and adjacent residential areas. And any future development site shall comply with all the land development regulations regarding height and scale and massing of the buildings. This slide got messed up somehow. So in conclusion, the request can be found to be consistent with the goals, objectives, and policies of the comprehensive plan. That concludes my presentation, and I'd be happy to answer any questions.
Very good, thank you. Any questions for staff? Okay, seeing none, thank you. Oh, I'm sorry, Mr. Roth.
I don't know if this is the appropriate time or not. Question is, can we do ALF in this operation?
Yes, and that's one of the requested uses, but it's not derived from the mixed-use portion of the site.
Thank you.
Very good, thank you. All right, any other questions for staff? Okay, seeing none, we're going to go ahead and open this up for public comment. Anybody in the audience who wishes to come forward and make a statement or ask a question regarding this application? Anyone at all? Okay, seeing no one come forward, we're going to close public comment and go to staff for closing comments.
Staff has nothing further to add at this time, Mr. Chairman.
Very good. Go to the applicant for a rebuttal.
No rebuttal, sir. Thank you.
All right, very good, thank you. Anything further from the Planning Commission? Okay, seeing nothing, I'm going to close the public hearing and open it up for discussion, deliberation.
Mr. Chair, I'd like to make a motion.
Very good.
Based upon a staff report, evidence presented, comments made at the public hearing, and finding the request to be consistent with the Community Planning Act as codified in applicable portions of Chapter 163, Part 2, Florida statutes, and the Manatee County Comprehensive Plan, I move to recommend adoption of Plan Amendment PA 2203, Ordinance 22-36.
Very good, we have a motion, is there a second?
Second.
Sorry, who was that?
Second.
Okay, Mr. Roth, very good. Any discussion? All right, Chair's going to call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 7-0. Very good. All right, next item, item number 5. Ms. Lidar, can you please read item number 5 into the record?
Yes, PDMU 1806GR, Village of Samaso South, BLN 22010023, and it's a quasi-judicial case. Amending and restated zoning ordinance number PDMU 1806G to revise the general development plan large project for 2,497 residential units, single-family detached, single-family semi-detached, single-family attached, and multifamily. 2,000 square feet of retail commercial, 245,000 square feet of medical office, 20,000 square feet of office, a 150-bed hospital, and 326 assisted living facility beds. The 1,032.3 acre site is on PDMU Plan Development Mixed Use and located northwest of the intersection of Moccasin Wallow Road and US 301 North at 12420 US 301 North Parish, and approving a schedule of permitted and prohibited uses as voluntary proffered by the applicant and attached an Exhibit B. The case manager is, again, Mr. Bill O'Shea, and here is the applicant to present the case.
Very good, thank you. For the Planning Commission, have there been any ex parte communications regarding this application?
No, sir.
Okay, none disclosed, thank you. Good morning.
Hello, good afternoon. All right, we'll be brief. Thanks for continuing. So my name is John Neal, president of Neal Land Neighborhoods, 5824 Lakewood Ranch Boulevard, Lakewood Ranch, Florida, and I have been sworn. I also brought my reflex hammer. I said I was going to tap the mic. So we're here primarily to talk about a hospital, but as this is a mixed-use development, we're also planning on talking about housing for workers, or what we can imagine are workers and nurses and also office workers in this area, as well as a neighborhood retail. What we are proposing is an amendment to a general development plan. Therefore, it has some general nature. I say amendment because what we're just doing today is refining a part of a project that your board has already approved. So first, a word on Neal credibility. I sort of laughed when I read this slide. It says 50 years experience, but if I look into my audience, Tom, we're more like 150 years. So we're experts. We're known primarily for building homes, but with Tom's help, we've also become a company that focuses on master plan development. Master plan development is somewhat more complex in many ways than building subdivisions, but it gives us an opportunity to look at some of the buzzwords that we throw around here, like walkability or connectivity or interconnectivity. So here's our team. You can see all the age. Somehow Pat had to slip away, but he's also on the team. Myself, everybody knows Ivory Matthews, and Tom Panasini in the back. So here it is. This is the center of the universe, what we call the center of the universe. It shows an approved development with 6,000 approved residences, an education mecca with a high school in the south, a future state college, a new elementary school, and to be announced this summer, or at this moment, a middle school in the center of the site. We also have a grocery store, walkable and connected grocery store that's under construction at this time, as well as homes from 350,000 to 800,000. So this is the overall plan, but what I really want to focus on and what we're discussing today is what's in this red oval or circle, which is what we need to zero in on. Let's see if I need to. What goes along with a plan like this is that we have some technical asks that we need to ask in order to make a project like this function, because it's not usual, it's not typical. It has a huge hospital in it, it has walkability and some connections. So I'm going to bring Katie up and also Ed to talk about the technical stuff. Oh, and Ivory has something for you here. You want that?
Thank you. Thank you, Commissioners. I'm Katie Labar, again, with Stantec, representing Neoland Neighborhoods. I have been sworn, and Ms. Matthews is handing out some amended stipulations. As I walk through this presentation, I will get to those, and we'll chat about those near the end of my discussion. As you've heard, the project is located at Moxonwalla Road near the intersection of US 301. The site is bisected by Fort Hamer Road through the center of the site. This amended general development plan is proposed to allow for 2,497 residential units, 202,000 square feet of retail commercial uses, 20,000 square feet of office, 247,000 square feet of medical office, 326 ALF beds, and 150 hospital beds. Due to the proposed density and intensity of the project, this is considered a large project according to the Land Development Code, and so it requires a higher level of scrutiny and analysis by the applicant. Higher level of analysis by us, a higher level of scrutiny by staff. And so we prepared a large project application narrative, and that was reviewed by staff during the course of review. As you can see on the general development plan, phases 1 and 3 consist of residential development, and to date we have approval for 1,325 residential units within those two phases. As John said, the focus of this amendment is primarily related to phase 2, which we have outlined in red on the screen, because it is the last remaining undeveloped phase of Amazon. We covered proposed future land use with the last item, but I think it's important to point out that the proposed future land use amendment consumes a very, very small portion of the overall project, and it fits nicely within the nearby and adjacent land use categories. Over the past several years, the vision for vision of a village center has really taken shape. And with that evolution, we've got to make some adjustments to the proposed entitlements. So with this application, we are proposing traditional neighborhood design, dimensional standards to promote a more dense, walkable area with buildings that will front on interior streets, placing buildings of similar character closer together to promote more of a campus-like setting, particularly for medical facilities. We understand that modern hospitals develop vertically, so we are proposing a maximum of 6 stories for the hospital use and 4 stories for office and commercial uses. The additional height will promote the continued preservation of open space and the protection of native habitat and wetlands throughout the site. The concept plan that you see shows retail uses like stores and restaurants near Moccasin Wallow Road, with office uses tucked behind the retail intermixed with apartments and townhomes. The proposed hospital and medical office campus is in the northwest quadrant of the site. Although the North Central Overlay District was recently eliminated from the Land Development Code, we have committed to maintain the 50-foot roadway buffers along thoroughfares, most of which are already installed and flourishing. And that is for the existing residential development that exists. And we are proposing 25-foot buffers with a very specific planting schedule that will be a very cohesive and natural transition. So we didn't want to disrupt the visual buffer as you're driving down each of these thoroughfares. And so we're maintaining that with consistent landscaping across the entire project, reducing the 50-foot buffer down to 25 so that there is some visibility for the commercial development that will be coming. And you will see details about that buffer in stipulation B10 of the staff report. And that, again, that is for the non-residential uses. With this amendment, we've also added a land use equivalency matrix, and that will allow for a trade-off of approved land uses while utilizing a conversion rate. And those rates are shown in the matrix, and it's heavily derived from trip generation, so it's really all about cars and trips. And this is really a standard practice for projects of this size, and it will enable staff to make it will enable us to make adjustments and staff to review and approve adjustments without too much back and forth and without necessitating board consideration, because those exchanges will remain within the parameters of what is approved within the traffic study. We've taken great care to limit any changes to dimensional standards to phase 2 only, so that we ensure the character of development and other phases remain consistent. And finally, I handed out amended stipulations. Those stipulations are for your consideration. We shared them with staff late yesterday, but it was too late to add to your update memo. And stipulation A11 is intended to address staff's concerns regarding mass along US 301. And so we propose to revise that language to require a 100-foot setback to apply to the portion of the building that exceeds 4 stories. 4 stories is already permitted here. We obtained approval for 4-story multifamily with the last general development plan approval. And so we believe that this stipulation is a nice compromise between what staff was asking for and what we think can be accommodated in development. We anticipate the building will have an articulated facade so that the portion that is taller will be consistent, again, with what staff has asked of us. And we believe that the proposed language is a balanced approach to overall site design, especially since the design continues to take shape and it's still not fixed, because we are far from the design phase of any type of a hospital. We also propose stipulation A22, and we provide an exhibit, that's on sheet 2 of what was handed out, to show the proposed building facade. Providing staff an example of the anticipated mass and scale will help everyone both visualize and contextualize the proposed building. With future administrative approvals, and the renderings will be submitted, and that will demonstrate compliance with this requirement. And it gives staff a greater assurance that the proposed architectural design will be a nice fit and will be an appropriate transition within North River Ranch. And so, we've taken great pains to work through a lot of the details, but it's very hard to commit to details when you're working in a general development plan. And so that has been the struggle for both us and staff throughout this process. I think that we have worked very hard to collaborate, to bring an application before you that we think will be a phenomenal addition to the community. I'd like to ask Mr. Ed Vogler, our legal counsel, to come up just to share a few final thoughts.
Thank you very much. Ed Vogler, Mr. Chairman, members of the board, I have been sworn. Thank you very much for the opportunity. Great comments from John and Katie. And one thing that we should say immediately is when your staff has concerns, we have concerns. probably the first thing I look at when I look at the staff report is the negative comments, because we have to know. And one of the difficulties, and this is very well explained, is when you have a mixed-use future land use category. That is the most intense that we have in Manatee County. And you say, well, why do you have that here? Well, it's the only category that you can have a hospital. And so we have to have the mixed use to have the hospital. And so when you come forward with a general development plan, you say, well, what is the architecture for the hospital? How big is it? What's the scale? What's the mass? You don't know. We can't ask our hospital provider to do these plans prior to the time that a hospital is a permitted use on this property. So as you've heard, we've done everything we can do to create the limitations. If you recall the prior public hearing, the D5 limitations, limits to hospital and other uses essentially in a master planned community. So this makes sense for use and scale and compatibility. So that's one set of limitations. When you come over to the general development plan, you have another set of limitations, the use limitations, the types of uses, the intensity of uses that are identified in the approval. So you say, well, wait a minute now, how big is a 150-bed hospital? Answer is, I don't know at this moment. But there are rules of thumb that scale that. Hospital rooms are only so big. Ancillary uses are only so necessary. You might have an ambulatory surgery center. We don't know that today. A lot of that will depend upon the provider. And these are the types of flexibilities that we need to have. So Katie used a very important word, which was balance. And so on one hand, we ask you for the authority to go forward with this project. On the other hand, we balance it with limitations that are objective and that will allow to be reviewed by your staff at a later time. And that is the nature of the GDP. And you know, and I know, that we struggle with that sometimes. But this is in the context of a very successful project in an area of the county that is growing, that needs these services, and we very much would appreciate your support in this request. Thank you.
Very good, thank you.
That concludes our presentation. We're okay with that.
Very good. Thank you.
Good afternoon, Mr. Chairman, Planning Commissioners. Again, Bill O'Shea for Development Services, and I have been sworn. Before we start with the presentation, I'd like to say that this was a work in progress up to the last minute. I've actually been updating the staff report while you were conducting hearings. So the staff report that you have received in your package is going to look significantly different than what the Board of County Commissioners is going to see. Staff and the applicant have come to consensus on a few items late yesterday afternoon. So I do have a PowerPoint that explains the changes and summarizes the project. I'll try not to duplicate anything that's already been said. So this project was originally rezoned to PDR and received PSP approval on March 20th of 2008. That plan, our preliminary site plan, expired. And then on September 4th, 2014, the board approved a rezone to plan development mixed use and a general development plan for 1,999 single-family detached residential units, 40,000 square feet of commercial, and 20,000 square feet of office. Again, the site is located north of Moccasin Wallow and west of US 301 in North County. Future land use category proposed is mixed use. You heard that application before this, and of course, the mixed use would have to be approved by the Board of County Commission and become effective before this, the applicant can proceed with this project. The zoning is PDMU, or Plan Development Mixed Use. So the request is to increase single-family detached, attached, semi-detached, and multifamily by 498 units, increase retail and commercial by 162,000 square feet, add 247,000 square feet of medical office, a 326-bed ALF, a 6-story, 150-bed hospital. They're requesting 4-story non-residential buildings, and this should have been updated. We're now down to 3 specific approval requests. The request also includes the construction of Phase 2 as a mixed-use village center using traditional neighborhood design criteria. And again, the existing entitlements that will remain in place are the 1,999 residential units, 20,000 square feet of office, 40,000 square feet of commercial retail, and the 4-story multifamily buildings. So I wanted to go over the changes to the staff report and the request. The first item is deletion of specific approval request number 4. That was to relieve the applicant from the additional setback requirements for buildings that have 4 stories or higher. To revise the alternative motion for approval to remove references to specific approval request number 4. To include a staff estimation of intensity, which I will go over in a few minutes. As indicated by Katie, the applicants proffered stipulation A22 with a rendering indicating that the hospital will either be in substantial conformance with the drawing or a superior design. And the applicant has modified staff recommended stipulation A11. Staff is in agreement with stipulation A22 and A11 as presented by the applicant. It also includes conditional approval language for specific approval number request, or specific approval request 1, which we were asking that if a specific approval 4 was not denied and we didn't get the 100-foot setback, then we weren't going to recommend that specific approval, but that's been removed as well. This is the site plan you've already seen from Katie, and the area shaded in gray is the mixed-use portion of the site. The specific approval requests that are remaining in the application are from sections 4015B2, B3, B4, and B5, which requires the front of the buildings to be oriented towards the roadway and to provide relief from architectural and material and/or color requirements for buildings above 3 stories. Staff is in support of that request. The second one is for a reduction in multifamily parking ratio, and there is a condition or a stipulation in the staff report that staff is in agreement with that, provided that a parking study demonstrating a reduced need is provided during preliminary or final site plan review. And the final request is to eliminate the requirement for a 6-foot solid decorative wall along the property line abutting a single-family site. Staff is in support of that request as well. So the positive aspects of the project: the site has frontage along existing thoroughfares. The proposed hospital will provide emergency services that are essential for this growing area in North County and will provide additional jobs and contribute to the county's economic base. Retail and commercial near housing enables residents to access these uses without driving long distances. The design provides 30% of open space, which exceeds the minimum requirements. Negative aspects: the floor area ratio cannot be determined based upon information provided by the applicant, but I will go through the alternative review of that in a moment. The proposed 6-story hospital cannot be fully evaluated regarding compatibility, as its location is not required to be delineated on a general development plan. Additional height to 4 stories for commercial, medical, office, and office uses will increase the perception of intensity in a relatively low-density intensity area of the county. And the location of the hospital helistop is unknown at this time and may create adverse impacts such as noise, vibrations, and light trespass at any time during the day or night. Mitigating factors: adequate separation and landscape open space is and will continue to be provided to address compatibility with surrounding ag properties. Stipulations A11 and A16 should address remaining compatibility issues. Compliance with Section 531.24 relating to the helistop has to be demonstrated during preliminary site plan or final site plan review. Stipulation A22, which shows the architectural detail for the hospital, will aid in reducing the mass and scale of the building. In conclusion, before I conclude, I did want to go over the alternative floor area ratio analysis. So this is really something that is required of the applicant, and they're not relieved of this responsibility to do so as this project moves forward. But there may have been an industry change. Trip generation and parking is normally associated or calculated based on number of beds. And that is what the applicant provided in their application. They did not provide us with square footage so we could calculate the overall floor area ratio. So I did a little calculation and research on my own. The maximum non-residential square footage from UF3 would be 14,975,78. From the mixed use would be 2,178,000. So the total maximum that they could get would be 17,153,078. The proposed square footages: we had the medical office, we had the retail, we had the office. There is information online that suggests that hospitals today require approximately 2,500 square feet per bed. So based on that information, the hospital should be somewhere around 375,000 square feet. For ALFs, in the information that we found, it's approximately 600 square feet per bed. So that would equate to 195,600 square feet. The estimated total square footage for the non-residential portion of the site is 1,039,600 square feet. The maximum, as I had indicated before, was over 17 million. So based upon that, we calculate at this time an overall project floor area ratio of 0.023. And when taking the different future land use categories and figuring out the allowance based on the percentage of the site and combining those together, the maximum floor area ratio project-wide should be around 0.38. Again, it will be incumbent upon the applicant to demonstrate compliance with the comp plan, but based on staff's calculation, it is reasonable to assume that this project will only be developed to a fraction of the maximum floor area ratio allowed. And again, that is 0.023 proposed or estimated proposal versus 0.38 for the maximum. And additionally, the applicant will need to provide square footage of the hospital and the ALF during preliminary and final site plan review and cannot exceed the 0.38 floor area ratio project-wide at build-out. So with that, to conclude, GDP approval is dependent on the companion application for a small-scale comp plan amendment becoming effective and the request appears to meet the applicable policies of the Manatee County Comprehensive Plan and regulations of the Land Development Code. That concludes my presentation. I'd be happy to answer any questions.
Very good, thank you. Any questions for staff? Okay, thank you. All right, we're going to go ahead and open up public comment. Is there anybody in the audience who wishes to come forward and make a comment regarding this application? Anyone at all? All right, seeing no one come forward, we're going to close the public comment portion of the hearing. And any questions, any information needed by the commission, planning commission? Okay. Mr. O'Shea, is there a printed copy of the amended motion? Or?
That's right here.
Okay, all right, never mind. I didn't realize it was handed out. I missed that. All right, with that, are there, yes, ma'am? Yes, Mr. Ron has one.
You got it. It's in the packet.
The amended one?
Yeah, the amended one's like the last page.
The amended one, the amended motion would remove the denial of specific approval request number 4 because it's no longer requested.
Okay. And I'm sure Ms. Shank will keep us on task.
We are supporting the specific approval number 1.
Very good, thank you. All right,
How about the A22?
that was omitted. Yeah, 822 was omitted, I mean added, I'm sorry. Yep. Yep.
When we're ready for the motion.
Got it. All righty. Any additional comments from staff?
Not at this time, Mr. Chairman. Thank you.
Very good. Anything from the applicant?
Nothing further, thank you.
Thank you. All right, with that, we're going to close the public hearing and open it up for discussion, deliberation, or Chair will consider a motion.
Mr. Chair, I'm going to try to make a motion here. Based upon the staff report and evidence presented and comments made at the public hearing, and find the request to be consistent with the Manatee County Comprehensive Plan and the Manatee County Land Development Code as contained herein, I move to recommend approval of Manatee County zoning ordinance PDMU 1806GR and approval of the amendment to a general development plan with the stipulations, with stipulation A11.
I was going to add
Okay, what,
on that, just to say, stipulations A1 through A22, and with the modification stipulation A11 as proffered by the applicant.
okay,
And then it continues, all the stipulations listed in the recommended motion, adoption of the findings for specific approval, and granting specific approval for requests 1, 2, and 3,
deleting 4.
And as specifically, subject to council plan map amendment ordinance 2236, PA 2203, and the text amendment becoming effective.
Okay, and then do we need to add in A11 and,
I read it in.
you read it in already, and A22? All right, thank you. That'd be my motion, Mr. Chair.
Can you repeat that, please? No. So,
Hey, can you repeat that, please?
Did anybody repeat that?
all right, we have a cobbled together motion. So, I think it's very clear what we're trying to do. So we have a motion,
Second.
Mr. Rutledge, second. Any discussion?
I just want to say, I'm very excited to see somebody take such an aggressive, difficult approach, because building a hospital, which I've done, or worked Main Street, Lakewood Ranch, is very difficult. But when they're done, they're great, and they're a big commitment, and we'll remember what you said. Anyway, but I think this is a great way to densify areas where we need to have services and everything. So I'm very excited voting for it.
And to that point also, I think this is something that if being done in this area, if it were done in other areas, we wouldn't have some issues like residential right up against the state highway. That's not the best approach. I think a hospital, would be a very, very good location for it. So with that, Chair's going to call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 6-0. 7-0, I'm sorry, 7-0. With that, we're going to go ahead and adjourn the meeting if there's no additional business. All right, thank you.
Thank you.